increase in eligibility work in progress.
Correct.
Applications ineligible, I think we've already covered that today. That's now 397. Is that correct?
Correct, which is 9%.
Thank you very much. Applications eligible?
4267.
Thank you very much. Offers sent?
2792.
No response to offer?
123.
Applicant in contact / querying?
9.
So a much smaller number of applicant in contact / querying.
Correct.
Disputes?
319.
Thank you very much. Can you assist us with approximately, if you're able to, how many or what kind of a percentage of those disputes involve individuals who are legally represented? It doesn't have to be an exact figure, but if we see there that the number of disputes currently is 319, can you approximate what kind of a percentage of those figures might be legally represented?
What I can help the inquiry with is the cases that are in our dispute resolution process. I am aware that I think the number is 70% are legally represented.
Thank you. And is that different to your categorisation of disputes here, and if so, why?
I don't think it is.
No. So about 70% are legally represented. Thank you very much. Offers accepted, you have there 2,248.
2,341.
Thank you very much. Again, are you able to assist with the kind of percentage that are legally represented? Is it the same or is it a different type of figure for those?
Legal representation across the entire HSS population is approximately the same. It's something like 12%. So legal representation across the total cohort is relatively modest. And yet the acceptance rate is now 84%.
84% who are...
Of offers. 84% of offers that are issued are accepted.
And of those, what kind of percentage are legally represented so far as you're able to?
I understand it's circa 10%.
Thank you. Settlements, 2,085.
2321.
Thank you very much. Total settlement figure?
118.5.
Thank you very much. Tax top-ups to HSS applicants?
14.8.
Thank you. Combined total paid?
230.1.
Thank you. We'll go through all of the charts that you have provided in your witness statement, or most of those charts, but can you assist us, in your view, what the differences in those figures, in your mind, shows?
If I may.
Yes.
Thank you. The one I would like, because when I got these Rule 9s, it was very much asking me about trends and patterns, and hopefully I can help the inquiry here. So if you look at the statement that's on the screen, you look at the combined payout of 121. If you then go down to the notes, so that 121 was at the end of May 2024. If you go down to the notes, you can see on the 22nd of August that 121 had turned to 139. And that's a difference of, rounding, that's a difference of about 18 million. So in those 3 months, in terms of redress on this HSS scheme, there was £18 million paid out. The number I've just quoted, as at the end of October, is 230 million. So the difference between the 139 and 230 is fairly significant. And I think what that does is, so what's that? That's about 90 million. Now that is over a period from August to the end of October. So that's a 2-month period. So if you compare the 18 million over 3 months and the 90 million over 2 months, I think what it illustrates is a rapid acceleration of redress. And that, of course, is purposeful because we need to speed this up and we need to accelerate redress. So that is a major trend I would like to use this opportunity to point out to the inquiry in terms of the acceleration of redress. And I go back to a previous statement I made this morning that we expect over across all the schemes is now 302 million redress, and we expect that to be over 650 million by March 2025.
And what do you see as the principal reason behind a speeding up of redress in that period?
That'll be more efficiencies and a better process, but predominantly because of the £75,000 scheme, which I know you want to talk about later.
Absolutely. So let's look at the average time it takes from eligibility to a decision. That's at paragraph 64 of the same statement. If we could turn to page 22, please. Thank you. So paragraph 64, you say for all non-BAT claims, so those are the standard claims and the complex claims, from the eligibility confirmation letter being issued, it takes an average of 470 days to an offer letter being issued. In respect of complex claims, this process takes an average of 514 days, improving to 306 days in 2024, although we note a lower volume of offers were issued in 2024. Can you assist us in reference to days there? In some places in your statement you refer to working days, in others just days. Are you aware of whether that is working days or all days?
Apologies, it should be working days.
Working days. For standard claims, this process takes an average of 445 days, and the data shows that this has decreased in 2024, with standard claims now taking an average of 302 days. So an average case took 470 working days. It's now decreased, but we're still talking very significant time periods, aren't we?
Yes.
What do you see as the principal reason for such delays? I mean, we're well over a year for an average claim.
The 445 you refer to?
Well, those are only working days, so if we include weekends, even more.
So they're not necessary delays, and whatever I say, please, I don't want to be taken as defensive at all, because it's not. This process takes too long. Full stop. It does take too long. However, there is a process that has to be gone through, and that's all defined and all operationally agreed and all signed off. Could it be quicker and could it be more efficient? Yes, and that's what we try to do continuously, and we will continue to do that. So and those days will include what I call lapse time. So when it's queuing, so when a case is queuing for the next shortfall analysis to be done, or the next case assessor to be ready to so there will be queues at each particular process point, and those days will include those. So this is not a true end-to-end picture, this is a reality picture, because this is what the postmaster is experiencing. So I'm not going to say, well, actually, because it only takes 2 days in legal review and 3 days in the SFA, that's a 5-day. No, it's when it's queuing, you have to include those days. The process is too long.
We see that there has been an improvement, and I think some of the explanation within your statement is that for the early claims, there were delays in, you don't call them delays, but I will continue to call them delays, relating to funding from the Department for Business and Trade. To what extent did those slow down the process from eligibility confirmation to the final offer being issued in those early claims?
Well, of course it did, because so to take, if I may add some colour to the whole thing and take a step back, everybody in this room will understand that the HSS was actually created from the GLO settlement agreement in terms of a scheme to compensate those not represented in the GLO. And that was the effectively activation date. So it was May 2020 when the whole thing started. But the scheme might have been announced and might have been started, but as with many schemes, including the recent appeal scheme announced by the government, it's just words on a piece of paper. There's no process, there's no anything behind it, there's no application behind it. So from May 2020, you've got to start building something. And that's exactly what was happening. And initially, the view was thought that, apologies, the initial view was that a number of claims would be relatively modest, and we're talking about a few hundred. And therefore, an engine was built accordingly. And then as soon as the volume started coming in and mounting up to 2,500 applications, is that point was that, well, actually, that engine is not going to be appropriate anymore. And by the way, Post Office haven't got those sort of funds to be able to support that. And therefore, we have to go to government and ask for it. And that starts the whole process around applying for funding.
Can you assist us with who was responsible for underestimating the number of potential applicants?
No, I can't. I before my time, and I don't know who would have been. I know there was a predecessor to myself who was appointed, but I understand that individual wasn't around for about 8 months before I started. So I don't know who that would have been.
Was there anybody in your role in that 8-month period?
Not that I understand, no.
I'd like to take you through the various stages of the application process and the offer process, unless you have anything else to say at this stage.
What I would say is, please, and to help the inquiry in the colour, and please, again, it's not. Please do not take this as be defensive at all. But the whole engine to be produced has to go through a huge governance process. So you talked about the consequential loss principles and you brought them up on the screen. And forgive me, I did say HSF and Post Office built those. But of course the panel, the independent panel, were heavily involved in their creation as well, which helps from the independence perspective. That whole engine in creating all those principles, creating the funding, creating the process to build, to make cases, allow cases to flow, took a considerable amount of time. And everything has to be agreed not only through Post Office, appropriate Post Office governance, but also government governance all the way through to Treasury, because at the end of the day, every process costs money.
Thank you. So moving on to the various stages, we'll start with the shortfall analysis stage.
Yep.
That process includes assessing or analysing whether a shortfall occurred and how much it's valued at. Who carries that out?
So my operational team carry that out, and how the process works is a postmaster in their application form will identify a time period when they thought they had a shortfall. The operational team, my understanding, I'm not an operator myself, my understanding is that individual will go into the system, into the Horizion system, and they are aware, they have experience of the Horizons, and therefore they know what they're looking for. Some of these members of staff have been counter clerks previously at post offices, so they have sophisticated knowledge of the Horizon system and how to look for these shortfalls. So they go into the date where the postmaster has identified, and they look 6 months before and 6 months after that particular date to look for that shortfall and identify that shortfall. And they have the skill sets to be able to identify that, but also to be able to identify whether or not that was an Horizon shortfall or another type of shortfall. If there's any doubt, the default is that it is a Horizon shortfall.
And we've heard throughout this inquiry about different types of data being available to the Post Office. We've heard about ARQ data, for example. What kind of data is it that they are accessing?
So they are accessing Horizon data, and they're accessing a number of other data sources. And if they want even further to go and get a branch file, they can go and get the branch file as well to be assured of a shortfall.
But when you refer to Horizon data, do you know what that means? Do you know what kind of
entries? So that they can look at the physical entries.
From where?
From at the time. So when the postmaster said it was the 24th of July, in whatever year, they can go in and look at the entries on those days. But they recognise that the postmaster, that may be a guess at the date, and therefore they go in 6 months after So they look at the whole year, 6 months after, to look for those entries.
And is that data provided by Fujitsu? Is that data from the Post Office's own archives or records?
So that will be Post Office, and some of that will be supported by Fujitsu.
You've said in your statement there's a low evidential bar. What do you mean by that?
In a language that maybe I understand better than most, is if the postmaster says it happened, it happened.
That seems like no evidential bar.
No, it is. It is because, and this is a panel thing. This is an independent panel thing. Cases go to the panel where we cannot find a shortfall. So it goes through the FSA process, and the postmaster have said, look, there were 5 occasions, and here are the dates, and we've looked 6 months after and 6 months before, where we looked at it all, and we always go to panel and say, we can't find it, we can't find anything. The panel then will go to the statements and all other evidence that has been coordinated by the case assessor, and they will look at it in the round and said, okay, we can't find any actual SFA technical evidence, but in the round, do we believe, given all that evidence and the file, do we believe a shortfall may have happened?
Thank you. And we're used to legal terms, balance of probabilities, reasonable doubt, prima facie case, credible evidence. Are any of those kind of legal terms used in the shortfall analysis stage?
In the shortfall analysis, is those, yes, in terms of the mindset of the individuals, they're looking to be positive about it. Is it formally in their terms of reference for operating what they're doing? No, it's not. But they are a bit like, as I said, the default is it is a Horizion shortfall if they can't find another reason. So it's an empathetic, sympathetic approach. They are looking for the shortfall. They're not looking not to find the shortfall.
And looking forwards to the ultimate offer, is it the case that the actual offers are in any way reduced because of the uncertainty at that particular shortfall analysis stage?
I believe not, no. The shortfall is just the trigger. It's just the trigger for the consequences of that shortfall.
So it won't be that because of a form of words that's used at that shortfall analysis stage about the certainty or uncertainty of the shortfall, that is then used at the offer stage to reduce or
That's not my understanding.
Can we please turn to page 58 of your sick witness statement? So the same witness statement, please, page 58. This is the average number of days it takes for that shortfall analysis to take place. We see there on the bar charts the average number of calendar days was significantly higher in 2021 and 2022. Is that correct?
Yes.
But we do also see from the volume that reflects albeit with a time lag, the volume of applications.
Yep.
Now, what we saw in the chart earlier is that after the Bates drama, there was, again, a second spike in those applications. We saw it earlier and then again in 2024. Does that not mean, and we see perhaps some effect of it there on the far right-hand side, that there's going to be another spike in volume because they have to go through the eligibility stage first, so there'll be an inevitable time lag. Will we not see a repeat of what we saw in 2021, 2022 later this year or early next year?
And later this year because of the mailing?
Because of the January 2024 and onwards spike in the volume of applications.
You will see that spike, yes.
And we'll see that in the number of calendar days that it takes for the shortfall analysis to take place. So
I hope not. I think there will be a spike, but we are busy as we speak of making sure appropriate resourcing is in place to avoid peaks in terms of longevity of time in eligibility. In addition, as the interim chair said in his statement, we are looking at some automisation and efficiencies in this space as well in order to speed that process up significantly.
Can you assist us with quite what's meant by that in terms of automation?
I can. Firstly, there's the automation of actual payments that we have already improved on, and we will continue to do that. And secondly, and it is related, forgive me for jumping your agenda, it is related to the £75,000 process, where we have talked about the SFA process. With the £75,000, we are not intending to do an SFA. We're effectively doing a shorter version of it, and we're calling it an SFI for future reference. And that's all been approved through governance, etc., for the £75,000 cohort, which we believe will be the vast majority of cases. And the big difference between the SFA and the SFI in terms of efficiency is that you're only looking for one shortfall. Under the SFA, if the postmaster is saying, I had 6, you look at all 6, you look at 6 months before, you look at 6 months after, you draw up your report, etc., etc. On the SFI, it's when you find a shortfall. And at that point, for all cases under 75,000, we will not be doing a review with HSF. So Post Office are going to be entirely doing that process.
So to clarify, and we will get to the 75,000, but you're not granted 75,000 just on fulfilling the eligibility criteria. You have to have the eligibility criteria plus a shortfall, is that right?
Correct.
Thank you. And you've spoken about increased resourcing. Can you assist us briefly with how you are preparing for a spike later this year, early next year, and into next year?
Hiring people.
Can you give us an indication of numbers before, after?
So I know we're currently in the process of hiring a further 20 individuals.
Okay, and when do you anticipate that will be completed?
My understanding is that will complete the hiring.
When, sorry?
Oh, so apologies. When? They're being hired now. So within the next few weeks, they should be in place.
Thank you. The next stage is the legal case assessment. Am I right to understand that a case assessor from Herbert Smith Freehills will compile a pack which includes their own assessment and analysis of the claim, which is then passed to the independent panel to consider?
I'm not quite sure whether it's an assessment. They coordinate the information they have. They get the SFA analysis, and then they do a legal review of the case, building the case on per heads of loss for consequential loss. The shortfall is the trigger, and they look at the claim and they assess, right, that claim means it's that consequential loss, and therefore I'll build the case around that. And what under each heads of loss, the assessor then outlines what the options to the panel could be for consideration under each heads of loss. So there might be 3 options under each heads of loss that the panel might want to consider. They're not guided to take those options, but it's things for their consideration. Once that pack is completed, that goes off into the independent panel.
Can you assist us with who at Herbert Smith is carrying this out? Is it junior solicitors, paralegals, partners?
A range, not partners, but a range of Herbert Smith appointees.
And do you have a view as to whether it's appropriate for Herbert Smith to be involved in this process, given their involvement in the group litigation, as we discussed earlier?
I think that the two are completely separate.
Do you know of any overlap of individuals involved, for example, in that process?
No.
Could we please turn over the page, please, to page 59? We see there the average days from starting legal case analysis to the offering, the issuance of an offer. And again, we see perhaps an increase in time, increase in number of calendar days it takes as a result of higher case volumes, that have reached that stage from late 2021 into 2022. So again, are we likely to be seeing a spike late 2024 into 2025 because of higher volumes? And if so, at the legal case assessment stage, how are you going to avoid that?
I hope not, because as previously described, the anticipation is on the existing cohort that are going through the process, and indeed future cohorts, the vast majority will be under 75,000 and therefore will not be subject to a legal case analysis.
Thank you. Moving on to the request for further information. During this process, Herbert Smith Freehills, the case assessor, might issue a request for further information, or they might request multiple requests for further information. Is that correct?
Correct.
Can you briefly describe what that involves?
That is designed to help the postmaster's application. It's not designed to hold it up, please. It's not designed to hold anything up. It's to seek further information to support their case when it's being put forward to panel. They are very empathetic approaches in terms of if we can get more information in this particular area, we might be able to assist you further. And that's what those requests for information are. And there have been occasions, and unfortunately it does mean the case takes longer, where there maybe have been 2 or 3 requests for further information, but they are well-meaning and well-intended to ensure that those cases have the best information possible for a positive outcome.
If we could turn the page, please, to page 60, we again have a chart of the average days from starting a legal case assessment to the RFI request. Again, very much the same trend that we see, a peak towards the end of 2022 and possibly a peak again starting in 2024. Once again, I think your answer will be that those will be cut down because of the £75,000 offer. Is that correct?
It would be, if I may add something, if it's helpful to the inquiry.
Yes.
In terms of the full colour of the picture, and again, please, this is not being viewed as defensive. Please don't take this as defensive. It's just the process that happens. Is an RFI, you're going out to the postmaster, and you're going, or indeed their legal representatives, to request further information. The whole process at that point is sort of out of your hands because you need that information to come back to help that case. So we are relying on that turnaround. And for good reasons, really good reasons, sometimes that's not instantaneous. And therefore that you have to build that lag into. And sometimes we do have a process of chasing down. And it's wrong to call it chasing. Following up is a better term. Following up those requests for more information. And that's all part of the process. But what it does is, in the words that you use, and I'm happy to use those words, it creates a delay.
Thank you. If we go over the page, please, we can see analysis of an average number of RFIs per case and also average number of days from starting an RFI to the final RFI response. We see at the top there, if we scroll up, thank you, an increase a gradual increase in the number of RFIs that are requested. Is that correct?
Yes.
Can you assist us with why that is?
I think that will be down to complexity, in that as the easier cases go through quicker, if there is an easy case, I don't think there is, the less complex cases go through quicker. And therefore the more complex cases, because of their very nature, and therefore the likelihood of more RFIs is more prevalent.
If we look at the bottom table, please, we can see a growing number of days spent on the RFI process. And as recently as the second quarter of 2024, the average time is nearly 120 calendar days. That's a problem, isn't it?
Yes, and any delay is a problem. I think these figures will also include the cases that are in dispute, and they naturally do take longer. And many of those, as I said, in the dispute resolution process are actually in the hands of legal advisors as well, and that adds a dynamic in terms of their caseload as well. Conscious that they have many clients as well.
But what we have there is, of all the years that this scheme has been operating, the current year actually has the highest number of days that are being spent on that RFI process.
I think that may be down to that factor, because a number of cases are in the dispute resolution process, and therefore the time it takes for the engagement on RFI and the return of RFI is more.
Can you assist us with what you mean by that in a little more detail?
So there are circa, I think, 350 odd cases in that dispute resolution process. They are more intense because the offer has been rejected, and therefore those postal and their legal advisors are suggesting that there's more significant redress needs to be paid. In order to justify that, in order to understand that better, Post Office will be asking for further information.
Why is it particularly in this year? Why is the average time particularly high this year?
Because the other normal cases, the non-disputed cases, are less, and we've got a more efficient process around those. And again, in the RFI process, it will be in HSF, or not at all if it's under 75,000. Whereas in the dispute process, it's still under that process, and therefore requests for information are required. And
in your view, looking forward, how can you avoid that increasing yet further?
The 75,000, again, I know we're going to get onto it, will help massively in that space, because we know a number of dispute cases will be able to be resolved with the £75,000 offer. So that will help enormously. But we absolutely need to get better and more efficient, and we are doing in that space.
So in the dispute resolution stage, can you assist us with what kind of proportion are actually claiming for less than 75,000?
I think the numbers might have been in my statement, but I think there are initially, we know the number that I've got in my head is 25% of cases could well be impacted positively by the 75,000. But that is a determination to be had by the postmaster and indeed their legal representative.
Thank you. If we could turn back to our survey at EXPG 607. It's page 60, please. Thank you. Page 60, figure 45. We have there the third bar is the time it took for the case assessor to assess your claim. Net dissatisfaction, 57%. 40% are very dissatisfied with the time it took for the case assessor to assess the claim. Does that surprise you?
No.
And why do you think that is?
Because it's not good enough.
Moving then to the independent panel assessment stage, could we please bring up onto screen poll 00448-026? These are the terms of reference for the shortfall scheme independent advisory panel. I'll just take you through briefly just to explain the background to this. We have at A1, the task of the panel is to assess and recommend to Post Office a fair outcome for eligible claims made to the scheme for shortfall losses and consequential losses. If we scroll down, it has there the panel's membership, and that comprises of legal specialists, forensic accounting specialists, and retail specialists, and it sets out below those who are involved. If we scroll down further to page 3, please, there's a section on general principles. At 31, it says, in formulating its recommended offer, the panel may recommend the making of an offer to the postmaster if, guided by broad considerations of fairness, the panel considers that doing so would produce a fair result in all the circumstances of the particular case. For the avoidance of doubt in doing so, the panel's discretion will not be confined solely to the specific heads of consequential loss claimed by the postmaster, but will take into account any facts or matters which the panel considers will produce a fair result on the facts of a particular case. Have you known the panel to make a recommendation that includes heads of loss that haven't been claimed by sub-postmasters?
I have known many cases where that clause 31 has been proactively used. I can't say with certainty whether that means a new heads of loss, but I have known that they, as part of the process, is once they've opined, made their recommendation, they step back and they look at two things: consistency with other outcomes and fairness. And I have seen them use that license to say, right, to be fair, we believe we need to adjust here, here and here. I also know that once Post Office have signed those recommendations off and the offer letter is produced, the offer letter goes back to the panel for sanction, and they take another moment then to assess the fairness of that offer.
Thank you. If we scroll down, there's a section on Horizion shortfalls, and it says where there's evidence that a shortfall in question existed and was paid, and there is no evidence that a shortfall was caused by something other than a potential issue with Horizion, for the purpose of the scheme, the presumption is the shortfall is a Horizion shortfall. I think that's what you've already addressed.
Thank you.
Consequential loss claims, the panel should apply the scheme consequential loss principles and guidance which are included at Appendix 1. In relation to personal injury claims, where insufficient evidence has been provided for a claim to succeed without further medical and/or expert evidence, the panel may recommend the making of an offer to the postmaster which the panel considers fair. The postmaster will then have the option of either accepting that offer or obtaining such further evidence and pursuing a personal injury claim in accordance with the ordinary legal standards relevant to such claims, including as to proof of causation and assessment of damages. So it may be that the panel itself makes a recommendation in respect of the personal injury aspect of an application. To understand your statement correctly, am I right to say that the recommendation that's made by the panel doesn't need to be accepted by the Post Office?
I have not known a case where it has not been accepted.
But am I right to say that technically it's only a recommendation, doesn't have to be accepted?
Correct.
Yes. And as you say, you've never made it.
I think we've increased a couple.
You've never made an offer, so far as you're aware, that is less than the offer that is recommended. On how many occasions, as far as you're aware, has the panel revised their recommendation on that second look that you've already explained?
I don't know, but I know the process does take place, but I don't know how many times they've taken the opportunity to revise it.
Thank you. And what is your role in respect to the panel? Do you attend their meetings? Are you able to contribute, observe?
Absolutely not. They're completely independent. I have no right of attendance to any of their meetings. They are independent. If I had any engagement with them, I could understand the optics of that. So absolutely not. The only time I've met the panel was when they presented to the advisory board.
Thank you. And how about in respect of the Department for Business and Trade? Do you know what interaction they have with the panel?
They have no interaction at all.
Thank you. Could we go back to your witness statement? That's sixth witness statement, WITN 09890600. It's page 62. We're now looking at the situation at the independent panel assessment stage. Page 62, you set out the average number of days from the last RFI applicant response to it being sent to the panel. page 62. And if we scroll down slightly, we can see that chart. Averaging, I think, 150 days from the last RFI response to be sent to the panel in the last section before we get to the right-hand side. Can you assist us with what the shading means on the right-hand side at all?
I'm afraid I can't.
No.
I don't know why it's shaded.
So it may be that those are accurate figures
I think they are.
for the fourth quarter. And in that case, we are now averaging almost, is it 700 calendar days between RFI application response and it being sent to the panel? Are those three bars on the right-hand side showing quite a problematic picture as far as the current situation is concerned?
Correct, and that's why we are addressing that.
And is that again the £75,000 offer or something else?
It is the £75,000 offer, and so some cases have been waiting for that to be activated, and therefore they will flow through accordingly. And I think the other one is that let's take a step back and see where we were with HSS as we moved into 2023. We were across 2023, we were effectively winding down the scheme because all we were doing was the later applications. So until the Bates drama came out, there was no peak. So we were downsizing, and indeed HSF were downsizing as well. Then the drama happened, and then the volume started coming in again. So we've effectively had to recreate the business once again in order to deal with the volumes. Now, it will be the 75,000 will help enormously in terms of that, but that has meant a knock-on effect. And one of the things that we have done is we've, in the month of September, we made sure that the panel now sits twice a week rather than once a week, and that will be moving into 3 times a week shortly.
Yes, I was going to address that. So there are about 1,500 applicants yet to receive an offer, is that correct?
Yeah, that's right. Yeah.
Yes. I'll be taking you to some correspondence with Hudgell's solicitors shortly.
Yeah.
But in that letter, you say that panel sessions recently increased from 1 per week to 2 per week, and that's 5 to 10 cases per session. Doing the maths, to get through those 1,500 applications, it's going to take more than a year, considerably more than a year, just to get to the panel stage for those applications. Is that right?
No, that's wrong because, and it's the overall picture that now we need to look at. There are 1,500 cases yet to, but the vast majority of those are going to be impacted by the 75,000. So the number is actually going to be a lot less. So that will bring that 10 per week, then will bring that in significantly. Correct.
Do you think, and as I say, we'll get to the 75,000, but do you think you're putting a few too many eggs in one basket in terms of that 75,000 offer?
The postmaster will have the choice about whether they're prepared to accept the 75,000 or they go for full assessment. My statement makes it clear on several occasions that the average payout redress for the HSS is £53,000. I sit here as a layman and I look at the average of £53,000 redress versus an increase in that, an offer of 75,000, and a slick, efficient, automated process. I sit here as a layman and look at that logically, and we've looked at our data in terms of the numbers of claims that actually are under 75,000, and they are the vast majority. Now, there is some mathematics and there is some logic in coming to the conclusion, therefore, that we believe the £75,000 offer will make a significant impact in terms of the operationalisation and the time of this process.
We'll get in due course to a number of issues, one of them being that there's potential for an appeals mechanism. So it's not entirely clear that those figures that settled for lower than that sum actually might not in due course seek to appeal the figures that they accepted. We'll also in due course see issues with legal representation.
Good.
And a high number of those that are accepted at that early stage not having legal representation. In light of those problems, those potential issues, might it not be that actually that 50,000 or so figure is wrong, and that actually ultimately people seek more than 75,000?
I think that's a potential, yes.
And won't that throw a slight spanner in the works when it comes to the predictions that you have for alleviating those problems that are imminent?
I think you can separate the two between an appeals process and between the applications that you're going to get in under £75,000.
What do you mean by that?
I think the potential appeals process, it's been announced, but there's no process behind it yet. That will deal with any case independently in government with anybody who wants to appeal. And they're not prepared to take the 75,000, that's absolutely fine. And if they're not prepared to take the 75 and an offer, then that will go through the full process. And I think the numbers that we anticipate in that we can cope with. Separately, I still believe that our anticipation is that a significant number of claims will come in for under 75,000, which will be able to process quickly without a legal review.
But
I hope
that anticipation is based on previous figures.
Yes.
Previous figures which themselves may no longer be accurate because people are going to seek to challenge those figures.
They may do that. I repeat my statement, and I recognise that only 10 to 12% are legally represented. I really do, and please, this is not defensive at all, but 83% accept their offer.
And do you read into that 83% are content with their offer?
I have to draw some conclusion to that. But I know what the legal advisors will say. You know, they're not well informed enough. Except I absolutely get that as well. But they have made a conscious decision to accept that. So I have to read something into that. And the appeals process, when it comes, will give them the opportunity to say, well, actually, I wasn't sure what I was signing at the time, and therefore I do feel this is unfair, and therefore I want to launch it. And great, that is fantastic. But they also might say, actually, it is, that I don't believe that was fair, but the 75,000 is now fair.
Have you planned for a scenario where, in fact, not as many people take up that £75,000 offer as you currently expect?
I have to. Yes.
And how are you going to deal with that when we see figures like this? The process, the RFI process, the case assessment process, taking a considerable number of days.
We have to be more efficient, and as the interim chair actually made it very, very clear, we'll have to automate more and be more efficient, and indeed, for example, introduce the SFI process much more aggressively into that population.
Thank you. You've said at paragraph 88 of your statement, we don't need to get it up, on average it takes 37 days from the panel assessment, panel recommendation to the offer being sent. Could we please turn back to our expert report from YouGov, EXPG 607, page 62. Page 62. If we scroll down, we can see their satisfaction figures in respect of the information provided by the Independent Appeals Panel and the length of time to consider the claim. Again, a lot more red than there is purple. Net dissatisfaction with how long it took for the IAP to consider the claim, 46%. Amount of information provided about the IAP process, 52% net dissatisfied. Do you have any views on those figures and why that might be?
I'll repeat myself. It's just not good enough, and I apologise on behalf of Post Office and in terms of the process that it takes so long. I do believe we get full and fair outcomes out of it, and as Sir Wynne has mentioned more than once from previous witness statements, it's the timeliness which is the issue, and Post Office apologised for the time it's taken, and it has taken too long. Am I surprised by these? Absolutely not. Am I doing something about it? Yes.
Thank you. The next stage is the Post Office review. That can come down off the screen, please. And that's when the Post Office reviews a recommendation of the IAP. Can you assist us with who at the Post Office reviews those recommendations?
Of the independent panel?
Yes.
We are told who it's going to be.
You receive them, though. There must be some internal discussion.
The names are put forward by HSF, and the names are circulated for interest. But we don't opine about whether we're supportive of that appointment or not.
Sorry, I mean in terms of the actual recommendation in individual cases that's made by the
apologies. Who sees those recommendations?
Yes, and who is involved in any kind of internal analysis or assessment of those recommendations?
There's no assessment of the recommendations. They are what they are. There's no challenge to those recommendations. It's me. I chair a committee that look at all recommendations that come out of the independent panel, and we understand how the panel have come to those recommendations and sanction them.
Once the recommendation is made and accepted, does the Post Office ever revisit those figures, even to increase them once the offer has been accepted?
Where there may be, the answer is yes. Where, for example, where we may have introduced a new heads of loss, we may have adjusted a principle or adjusted a heads of loss because of a new case that has got a nuance in it that hasn't been considered before, then actually we don't put anything on hold, but we realise that actually that might impact previous cases. So we do a backward review with the panel's assistance. We do a backward review on all cases that might now have this additional nuance in it, and we adjust.
Approximately how many times have you had that backward review process?
I don't know, but we've definitely had one. But there is the opportunity there for. I'm sure it's more than one, but I can only recall one.
And in that one, was there a revisiting of earlier acceptances and communication made with those surveys masters?
Correct.
Thank you. If we go back again to the expert report, EXPG 607, I think this is the final time that I'll take you to that report, page 63. Thank you. Page 63 has the satisfaction with the amount of information provided and how the application outcome was determined. If we scroll down, we can see in terms of the time it took, 52% net dissatisfied. The offer amount, 59% dissatisfied. The amount of information provided to you about how the outcome was determined, 49% net dissatisfied. If we go over the page, onto page 65, please, there's figure 49. Reasons why applicants were accepted, the offer in part or full, and we only have a figure of 15% who say that they accepted because they were satisfied with the offer. What's your view of those figures?
Obviously, extremely disappointed. I think where I struggle, and I know it's simply an optic, and it's simply numbers on a piece of paper. I need to talk about numbers on a piece of paper, please, if it helps the inquiry. Is that the 15% satisfied? It doesn't tally in my mind with the 83% acceptance rate. That's where I struggle. But what concerns me more around these, and I looked at these numbers in particular, what concerns me more about this page is that the process just to finish is 51. That really concerns me. And that goes to what some legal advisors have been saying to me as well, that people just want this done, and therefore whatever you put in front of them, they're going to sign because they just want to walk away from it now. It's taking too long, it's too legalistic, etc. You're putting too many barriers in. So that does concern me. On the more optimistic side, what I'm hoping is that the new appeals process, when it's ready, hopefully in the new year, will be able to accommodate those people to say, right, I wanted to finish, but now I've got the appeals process. I wasn't satisfied with that. I wanted to finish, but I wasn't. I can now apply to that.
Thank you. That can come down. I'm going to move on to the dispute resolution process. I'll introduce that briefly before we break for lunch, but we'll have to return to it after lunch. The dispute resolution procedure applies if the offer is not accepted by the postmaster. Is that correct?
Correct.
It's assigned to a case manager. Can you assist us with who a case manager is?
It will be a member of my team who has a broad knowledge of Post Office and how it operates, but specifically around how to deal with disputes. And the team is currently 23 people, and they all have their own portfolio of cases.
There's then a good faith meeting, and the next level is what's known as an escalation meeting. Okay. Is that correct?
So there are four layers of dispute resolution process, all determined actually by the GLO settlement in terms of when the HSS was established. It was agreed that a dispute resolution process would be established, and therefore it's pretty within given terms that we had to create a four-layer dispute process. So good faith, escalation, mediation, arbitration.
Thank you. In terms of a good faith meeting, can that result in an increased offer from the post office?
Sometimes, yes.
And has it resulted?
Yes.
After the good faith meeting or the escalation meeting, it can then go back to the panel, can it? Is that
it can,
correct?
Yes.
Is there a maximum number of times that it can go back to the panel?
No.
Is that set out anywhere in any of the terms of reference or guidance in respect of the process of it going back to the panel and how often that can happen?
Only going back to panel only internally, into say the process is once we think we've gathered enough information that may change the view, then it goes back to a panel. But as no doubt you've picked up from recent correspondence with Dr. Hudgell, is that we are now adjusting that to say if the legal representative or the postmaster actually don't want it to go back to panel, and would prefer Post Office to take a commercial view on that, then that's fine as well. We're beholden to what the postmaster and what their legal representatives preferred option. There's no separate. It has to go back to panel if that's the question you're asking.
And then finally, you have the formal mediation with Wandsworth Mediation
Yes.
Service. Does that take place? Has that taken place?
Yeah, it's taken place quite a few times, and so far successful in every occasion it's been used, and some positive feedback on it as well.
I'm going to return to this topic after lunch, but that's an appropriate moment to take our lunch.
Yep.
Thank you, sir. At 2 o'clock, please.
Yep, sure.
Good afternoon, sir.
Good afternoon.
Mr. Recaldin, we were on the topic of dispute resolution. I'd like to bring up onto screen your sixth witness statement at page 67, please. Paragraph 185. You address there some figures in relation to dispute resolution. It may be that they're slightly out of date now because they were based on the position as at the time you wrote the statement. Actually, sorry, before I get to that, just to say, in your evidence earlier, I asked you about calendar days and working days. And it's been brought to my attention that where you use the term days in your witness statement is calendar days rather than working days.
Thank you.
If we have a look at that dispute resolution procedure section, it says, of the 2,720 offers made, 532 have been disputed. It says 86% of legally represented applicants dispute their offer, compared to only 11% of non-represented applicants. So it's much more likely that there will be a dispute where somebody is legally represented. Is that correct?
Yes.
If we go over the page, please, to 185D, you say there remain 383 unresolved disputes with an average time in dispute of 14 months, of which 261 have not yet gone through a good faith meeting. Some feedback from legal representatives is to bypass the good faith meetings and go straight to the next escalation stage to speed up resolution, which is why the process is approached with a degree of flexibility. Average time in dispute of 14 months, I mean, that's a very significant time period, isn't it?
Yes.
And what do you say is the principal cause of that delay?
I think, well, there are a number of things. Could it be done quicker? Yes. I think in this part of the process, however, it's really important that we have continuous engagement with the legal representation and also with the postmasters, and that inevitably causes delay. Your term, I call it a process, but I understand why that can be viewed as a delay. So that is deliberately put in there, the 261 that haven't yet gone through a good faith meeting, because there are legal advisors who say we were not in dispute, we just want to understand more. So we want to understand the offer better, and we're waiting for advice from our clients about whether or not it needs to enter into the dispute process. So it's almost like a waiting room until the legal advisor gets clarity from their client around whether or not it is a dispute or not, and that's why they've yet to get to a good faith meeting. However, there are cases, quite rightly, where the good faith meeting is bypassed, and that's why the process is flexible, and the opportunity is there to go straight to a face-to-face escalation meeting.
Can you assist us? You have there the average time. Do you know how long the longest time period for a particular case has taken?
No, I don't, but I know I would be very embarrassed to know what it is.
Because it may be years.
I take it that there are cases still unresolved which were part of the cohort of cases which began within the original time frame, which would mean that we're 4 years down the line, wouldn't it?
From May 2020, when they may have been submitted, yes, Sir Wynne.
Yeah.
And do you think that's a handful, tens, hundreds?
Not hundreds, but certainly tens, yes.
Thank you. If we could please go over the page to page 69. We have there the proportion of offers disputed by date of first offer. And it looks as though in parts of 2023 into the beginning of 2024, you have somewhere approaching half of the offers being disputed. Is that right?
Yes.
And we see there towards 45%, for example.
Yes.
We'll get to the letter from Dr. Hudgell shortly, but one of the complaints that was made in that letter is that the escalation meetings are difficult to secure and don't lead to tangible follow-up. I think you've reflected on the number of meetings, of those escalation meetings, and you've said that there will be a further increase in their frequency. Is that correct?
Correct.
Do you recognise that those meetings have been difficult to secure?
I have to say, Hudgels and Post Office have worked, what I think, collaboratively together consistently. And I don't believe getting dates into diary, if that's what this means, has been a struggle. I don't believe that is the case. I think I'd like to think we're very collaborative in terms of getting those dates in diaries.
One of the cases that they highlighted was a case where a figure was agreed, but there had been months of argument as to which head of claim that amount fell under. Is that something that you are aware of?
I am aware of that case, yes.
And what are your views as to what I would call delays in that particular case?
I'm disappointed, and we need to be better at it.
Are there plans to resolve that?
Yes.
Imminently?
Yes.
And what about the resubmission to the panel? Does that build in further time?
Yes, it does. The resubmission to panel is a bit of a consistency, because the panel provide that consistency and that optic of fairness of the outcome. And it's, we believe it's an important part of that process for that consistency and for absolutely that independence. But we also recognise that could lead in delay. There's another legal review requested in terms of a resubmission into panel. It then has to wait for their next panel meeting, then they opine, and then the recommended. So that's a process that does take time. And we recognise that to avoid that, we are now offering an opportunity that instead of going back to panel, we can have a face-to-face negotiation directly with the legal advisors and the postmasters. And
since when has that been in place or communicated?
So that's been in place consistently, or has always been there, but we've always followed the process of going back to panel, not every time, but we have a commercial flexibility in order to settle. But most of the time we do go back to panel for that consistency perspective. So in terms of additional flexibility and allowing the legal advisors to make the call, and obviously their clients, that is something which you will have noticed that was in my correspondence to Dr. Hudgel last week.
So that's a relatively new process.
Yeah.
I won't bring back the survey onto screen, but in the results, more were dissatisfied with the dispute resolution process than satisfied. I think it's small in numbers, but 16 against 4 who were satisfied. Again, do you have any views on that?
I'm disappointed, but not surprised.
We then have the arbitration level. That's for claims over £10,000. Is that correct?
So we've never experienced an arbitration, and the £10,000 is now effectively is ineffective now because of the 75,000 scheme of the offer. Again, we've never actually been to an arbitration, so we've never sort of formalised that process at all.
Thank you. In terms of an appeal mechanism, there's been discussion about an appeals mechanism. Can you assist us with what the current plan is for that?
The appeals mechanism actually came out of this inquiry. And Sir Wynne and the inquiry very helpfully suggested some areas that the inquiry might bring forward for attention, such as the fact that consequential loss principles were issued after the scheme was launched, the fact that legal representation was not supported at the point of submission of claims. And Sir Wynne very, very helpfully listed a number of questions and challenges around what could be the implications of these. So Post Office, doing their best to listen, if I may say that to inquiry, went away to consider those challenges and those issues and said, and how could we address those? And at the same time, actually, the advisory board also came forward to advise the Department of Business that, in their view, that an independent appeals process for HSS cases would be appropriate because of the inherent mistrust, I use the word, the inherent mistrust of anything coming out of the Post Office. that might be slightly unfair on the advisory board in terms of their advice. And at the same time, because of the challenges that Sir Win and this inquiry gave us around these issues, we thought, well, actually, a resolution to all these issues could well be an independent appeals process. So even if cases have settled with us, then actually, if the recipient, the victim, feels they have had an unfair outcome, despite the fact it's from an independent panel, etc., then they have a right to an independent appeals process.
And has that been implemented?
So the government actually announced its intention to bring that forward. I think under Minister Hollingworth at the time, I think in March of this year, it was announced in the House of Commons. We then had purging and we had an election. And therefore, new ministers had to be appointed and new ministers had to be brought up to speed. And I understand, and there has been an announcement in the House, that the new minister is also supportive of such an appeal scheme. So that has formally been announced. The actual process behind that is being built, I understand. But again, Post Office are willing to help, are helping to build that, but that has to be independent. It cannot be tainted with Post Office. I completely understand that.
So
and that'll be run by the government.
It'll be run by the government. Who's building it at the moment?
So the Department of Business and Trade are building it, as I understand, as we speak.
Have you made any projections as to anticipated take-up of that mechanism?
No.
Do you have a view as to how likely it is or not that the numbers are going to be of significance?
I think through the helpful YouGov survey and our live experience, I think we can help very much in what that may look like. And although it has not been agreed, one step that has been discussed in this appeals process is the potential transfer of the dispute resolution process into that appeals process. Hasn't been agreed. It's one thing that is being considered.
In terms of the overall perceptions, as you've said, they're set out in the YouGov survey. Perhaps we could bring that up again. That's EXPG 607, page 67, figure 50. Page 67. If we scroll down, we can see overall satisfaction levels. And I think this is something that may give you, as you say, an indication. We have there figures for those who said that they were fully informed at every stage of the process. Net dissatisfied 48%, that the scheme was easy to understand and navigate. Net dissatisfied 49%, that you had enough information to make informed decisions. Net dissatisfied 52%. With the HSS overall, net dissatisfied 49%. With the time it took from starting your application to reaching the end, net dissatisfied 48%. With the amount of compensation received, net dissatisfied 43%. And as you can see there, that was 1,430 respondents to that part of the survey. Again, do any of those surprise you?
What maybe I can hopefully to help the inquiry is they disappoint me again, but they don't surprise me. My experience away from the Post Office in remediation schemes, this sort of feedback is not unusual. Unfortunately, it's just not unusual. It's remediation. Something has gone badly wrong for anything like this to be active, and boy has it got wrong in this space, right? Absolutely gone disastrously wrong, and therefore any recoup from that position is always going to be a struggle. So yeah, the figures are just not good in terms of 49% are overall dissatisfied, 51% might be partially satisfied, and that's what, in a remediation scheme, that's what you have to hang on to in terms of the positive. So I'm very disappointed, absolutely, but not surprised, simply because of the nature of my experience before Post Office of remediation schemes.
Thank you. That can come down. If we address issues of delays, you've already addressed them this morning. You've set them out in detail from paragraph 104 onwards in your statement. I won't bring that back onto screen. I'll just go through one by one of the various reasons you give for delays. The first is the issue of funding, and it's a matter that you've already addressed today, that, for example, panel members are only appointed in June 2020, funding sign-off from the Department for Business and the Treasury was not until March 2021. So am I right to summarise that in your view, one of the reasons for what I call delay, what you call process, is issues with funding?
Yes.
Second, you referred to high volumes of applications and their complexity. You say that the 2,548 claims by September 2020 was unanticipated. I think that's also the evidence effectively you gave this morning. Is that right?
Yes.
There's been complexity such as taxation issues, the official receiver and bankruptcy issues, issues with creditors. Can you very briefly summarise those kinds of issues for us?
Well, when you any activity where you are required to engage with a third party, then an education process has to take place, and you are dependent on the third party. So bankruptcy is a great example, and insolvency, etc. So that will always take time to feedback in how you're going to deal with those cases. If I may, the one thing not on that list is the governance around the establishment of the process, the drawing up of the principles, and we talked this morning around HSF and the panel assisting us, and indeed we need to include the government in that process as well, in terms of drawing up all those principles and those processes and getting them all signed off at a multitude of levels. I think last time I counted, there are 12 stakeholders that I need to keep happy, and in particular in this very sensitive space. That is a challenge for any organisation to be able to do, to keep those 12 stakeholders engaged and comfortable and have a say in a process design.
Thank you. Sticking though with the bankruptcy issue, you've addressed that in your 8th witness statement, and perhaps that can be brought up onto screen. It's WITN 09890800. It's page 3 where the issue of bankruptcy is addressed. You say there, in relation to claims concerning bankruptcy, there are 56 outstanding claims which were made between the 1st of May and 27th of November 2020, all of which have received an offer. 15 outstanding claims which were made between 28th of November 2020 and the 31st of December 2023, and 87 outstanding claims which have been made since the 1st of January 2024. Is this a particularly problematic group of cases?
That's not the feedback I'm getting. I mean, clearly there's a separate process for bankruptcy cases. We need to understand what the bankruptcy court are interested in terms of their take on this. And we do split the heads of loss that we can pay directly to the postmaster, and ones that we need to be committed to the bankruptcy courts, etc. So it hasn't been raised to me as a particularly troublesome area. But again, and I know we will get onto it, a number of in particular the 87 may be resolved by the £75,000 process.
Thank you. That can come down. I'm still going through the various reasons you give for delay. The third is shortfall analysis. I think we've already dealt with that, and you've said it could possibly be sped up by just looking for one shortfall rather than multiple shortfalls in future. The fourth is later applications. So the scheme reopened in October 2022, and you had 230 claims waiting to be addressed straight away. So those are ones that had been stacked effectively. Is that correct?
Correct.
Following the Mr. Bates ITV drama, there were 1,345 applications between January and May 2024. So a large number of applications. Paragraph 120 of your 6th statement, you accept that you were not resourced for that increase in January 2024. Can you elaborate on that, please, for us?
Absolutely. So until that point, we were effectively planning closure of the HSS, and indeed had a tentatively agreed date with the government about when we would close the scheme, simply because we knew how many late applications we were getting in, and therefore could project how long the scheme needed to last for. Now, we'd have still issued a reminder for people to come in if they wanted to, but it was clear from the traction that we were getting and the numbers of new claims coming in that it was deteriorating. They were coming down to a handful a week. And therefore we were planning to effectively close the HSS scheme with government permission, etc., etc. So we downsized the people accordingly. Can't have people sitting around not doing anything. So both HSF and Post Office started decreasing the number of people on the scheme.
So in terms of your staffing and support, what was your team size as at, say, December or the very beginning of January 2024?
Beginning of January, it will be a circa 200.
And how has that changed since then?
We're now increasing significantly, as I said earlier. We're now recruiting in order to anticipate the peak of activity that we have. That said, we're also automating, and therefore we're going through a careful planning process around the people we potentially release through automation. We're using, hopefully we're going to transfer their capabilities, their abilities to other areas of the business.
If I can pick you up though on the recruitment, I think your evidence was the recruitment process is taking place now.
It is.
The increase in numbers took place in January, February 2024. Were you doing anything about those numbers in the intervening period?
So the numbers in 2024 are the consistent numbers that we've had in the RU remediation unit across. That's been fairly consistent. It's only the recent recruitment where those numbers are going up.
But in terms of the number of applicants, that shot up. We saw those figures after the ITV drama.
Yeah.
Did the number of people within your team shoot up accordingly, or is it just more recently that you have turned your mind to increasing numbers in your team?
More recently, in terms of the impact of those cases coming through.
And why do you think it is that thought wasn't given to increasing numbers before now?
It has been, and forgive me, I was talking about Post Office, so don't forget a lot of this process is within Herbert Smith, and they had downsized and they had started increasing at that time. So in early 24, they were increasing their numbers to deal with the peak.
Thank you. The fifth reason you give it is agreements pertaining to tax treatment, interim payments, eligibility, bankruptcy and insolvency. Under that heading, you've also discussed issues with having to liaise with the Department for Business and Trade. Is there a figure at which you have delegated authority to settle cases without having to refer them or refer matters to the Department for Business and Trade?
Yes.
Is that something you're able to give an indication of? Is it most, some that fall within under that?
Very good question. I would say some.
But in the majority of cases, you still have to go back to the department for authorisation.
I would say more than that. Well, certainly, and I'm absolutely guessing here, but it feels like a sort of 60% still need to refer to further authority levels. So I haven't been. My authorities matrix is very complex, and I certainly haven't been given the mandate to settle at whatever cost. That would be wrong as well. But I haven't been given a complete flexibility in that. No.
And do you think the level that it is currently at is too low, too high, just about right? In order, looking at the cases that we need to resolve, I would say currently it's too low. And are steps being taken? Have you had discussions with the department about this?
Continuously.
And are they open to changing that?
Yes.
Do you foresee that changing soon?
I hope so, correct.
The sixth, and one that we're going to come back to and possibly spend quite a lot of time on, it is the legal representation and legal representation costs. Those costs have only been available since October of 2022, is that correct?
Yeah.
They're not available at the application stage, they're only available at the offer stage, is that correct?
That is correct.
Could I please take you to page 39 of your sixth statement? So that's WITN 09890600, page 39, paragraph 127. So you say at paragraph 127, some applicants have been instructed legal representation from the beginning of their application process. While the data shows that this makes a minimal difference to the eligibility outcome, we have received proportionately more consequential loss claims as a result. Although available to all upon request, the data appears to show legal representation has also been a driving force in applicants receiving an interim payment. So it seems as though those who do instruct their own lawyers are more likely to claim for consequential losses and are more likely to claim for interim payments. Is that a fair understanding of that paragraph?
That's a very fair understanding of that paragraph.
And does that not suggest that the ability to claim for those might not be sufficiently identified to those who don't have legal representation or sufficiently known by those who don't have legal representation?
I think that could also be a fair conclusion. If it helps the inquiry, if I may step back slightly, and I think the inquiry will recognise that the GLO and the activation of the scheme, the term legally light has been used quite a lot because the GLO membership was so burnt by the legal process which they were forced to go through to get the absolute right outcome for them and for the other postmasters as well. And therefore their insistence was that if for any other scheme would be legally light. And that's why the HSS was originally built that way, to say, well, we want to make this a legally light process and therefore you don't necessarily need legal advice for the submission, but you can have legal advice when the offer is made. Now, and we'll support that. That was the theory behind why there wasn't legal advice. Now, I recognise the optics coming out of my own statements, and indeed the YouGov, etc., it's pretty clear that statement is accurate by looking at the data. The applicants who do have legal representation apply for more consequential loss heads of loss accordingly.
And as a result, do you think a lesson learned is that actually legal representation at an earlier stage could positively benefit the scheme?
I think it can, but again, please, it's not defensive at all. I struggle, therefore, with why 83% seem to be satisfied, and the vast majority of those without legal advice.
When you say satisfied, we saw from the survey results they weren't necessarily satisfied. What you mean is 83% accept the offers.
You're absolutely right. I apologise. They have settled.
Yes.
And therefore, I just struggle with that sometimes. But I'm sure you will go on to the fact that the ones who are legally advised at the offer stage and beyond, their average redress is greater. Absolutely. As well. And I absolutely get that as well.
I think you've said that the background to that is that the sub-postmasters wanted it to be legally light. Is it not also part of the story that the Post Office and Department for Business or whoever else was involved in designing the scheme may also have wanted to avoid having lawyers at an early stage in order to save costs?
I think that was probably a consideration. I wasn't there, but I think it probably was a consideration.
one thing that you've said at paragraph 139 is that it's regrettable that the Post Office didn't send the consequential loss guidance to all potential applicants. Have you done anything to highlight what consequential loss is, to publicise its availability to those who may not be aware?
Yeah, I mean, it's comprehensively covered on the website, and we direct everybody to that. We also have a customer care line, in fact, a customer support line when postmasters ring in, legal advisors ring in, and we can point them in that direction.
We'll come to that. So that was your sixth reason, legal representation issues. Seventh, in terms of delay or time that things have taken, is the dispute resolution procedure. That can come down, but at paragraph 130 you say, when the applicant rejects their offer, this is often the time when the applicant obtains legal representation, and that's meant that further information is then presented, new heads of loss. So when somebody instructs a lawyer, which is only available as of right once an offer is made, then they may, for example, provide new information or further heads of loss. And that, again, builds in time to the process. Reflecting on that, doesn't that justify the instruction of lawyers at an earlier stage? Because if you had that information or those heads of loss at an earlier stage, before the offer is made, that might avoid the delay or time taken after the offer is made.
I cannot see a flaw in that.
I think you say in your statement that it elongates the time that it takes to settle as a result of
Correct.
that new information. Moving on now then to the fixed sum offer and the top-ups.
Before you do, Mr. Blake, have you left the topic of appeals? Because if you have, I just want to ask one or two more questions about that before you start another topic.
Yes, please, sir. Please do.
Right. Mr. Recaldin, perhaps we could have paragraph 139 of Mr. Recaldin's witness statement on the screen, and that's at page 42. And this is simply to give us a reference point, really, Mr. Recaldin, for the point I want to pursue with you. You will see that the second part of this paragraph actually deals with what an appeal may deal with.
So we're just waiting for it to come up onto screen.
Yeah, sure.
Thanks. It's page 42.
Right, so I'll come to this paragraph in a second. Let me just ask you one or two basic questions to make sure I got it right. The possibility of an appeal process was first mooted earlier this year and not before that. Is that correct, Mr. Recaldin?
There was a recommendation from the advisory board. Forgive me, Sir Wynne, I don't know when, but it was before March this year. And there was a recommendation from Post Office about the same sort of time as well for an independent appeals process.
And then the government announcement was March this year.
I think so. That was, yes. It was Minister Hollingworth.
That's fine for these purposes. And I'm right in thinking from what you've said that the appeal process will be both formulated and administered by the department, not by the Post Office.
You're absolutely correct, Sir Wynne.
Right. But this is now coming to the nub of what I want to ask you about. Since March 2024 to the current date, has the department, in inverted commas, consulted with the Post Office, as far as you are aware, about the grounds upon which an appeal might be brought?
No, since March, yes, they have recently, Sir Wynne.
And when you say recently, do you mean within the last few weeks or what?
I do mean within the last few weeks.
Right. So there is still work to be done, if I can put it in that way, in formulating what might be regarded as at the heart of any appeal process, namely, upon what grounds can you bring an appeal?
Correct.
Right, okay. And I use this paragraph, 139, because in it you say that the Post Office hopes that the appeals process might assist with remedying people who were unaware that they could bring, say, consequential loss claims.
Yes, sir.
Yeah. So there's still a great deal of uncertainty, am I right, about the basis upon which any appeal can be brought?
There is uncertainty on the basis of which appeals can be brought currently, yes.
And does that uncertainty extend to having to decide whether the appeal process will be open to everybody who has thus far participated in HSS, regardless of whether they've settled or not? Or is there still a debate going on about which category of HSS claimant might be eligible to appeal?
I think that is being discussed, whether or not it's open for everybody, or whether they're, my words, so whether there's a filter on that, on what types of applicants can apply to it. I think that is yet to be determined.
All right, well, when Mr. Cresswell gives evidence on behalf of the department, he may be able to place more flesh on this particular bone. But doing the best you can, does it look to you as if we are some months away from formulating both the criteria for bringing an appeal and the process for bringing an appeal, and therefore some months away from this appeal process beginning?
So when on the limited engagement I've had with the department on this, I understand there is a strong appetite to have something up and running in the new calendar year.
Well, those are very carefully chosen words, if I may say so, Mr. Recaldin, because something up and running in the new calendar year could span from January until December, couldn't it?
Okay, let me be fairer. Let me be fairer to the government's Department of Business and Trade. Again, the limited engagement they've had with me and my team is that they are certainly under pressure in order to produce a process, and the articulation, the verbal articulation they have is that they are under pressure to be able to do something, to announce something in terms of a process in Q1 of the next calendar year.
All right, thank you. I wasn't trying to tease
No.
you, Mr. Recaldin. Do you know if, just if you don't, please say so, but do you know if there has been any consultation between the government and any groups representing postmasters about both the likely grounds of appeal and the process generally?
No, I don't.
Fine. All right. Thank you very much. Sorry, Mr. Blake.
Not at all. Thank you. So we'll move on to the fixed sum offers and top-ups. As you've said already today, that the average that was paid was originally £52,000. And from the 9th of August of this year, a fixed sum offer of £75,000 was introduced and is also provided as a top-up to those who had already settled for a figure below that. So we have top-ups to those who have already settled that increase the amount that they are provided up to £75,000. You have an offer to those who haven't yet settled for £75,000 for any figure, an offer of £75,000, and you also have are communicating this offer to those who haven't yet applied for any redress. Is that correct?
Correct.
Can you briefly explain the background to the 75,000 and whose idea it was and where it came about?
So the background of the 75,000 was effectively a minimum payment introduced into the new GLO scheme, which, as we know, is operated by DBT, Department of Business and Trade. And the government recognised straight away, as the Post Office, is that if that was being offered in the GLO space, it would be absolutely appropriate to also offer the same in the HSS space. But as ever, there are differences between the GLO scheme and the HSS scheme. So grateful, willing to adopt that, but of course we had to incorporate that into new processes because the HSS cohort is a different cohort to the GLO cohort.
If you accept the 75,000, are you foregoing other rights? And including, as Sir Wynne has said, in terms of those potential appeal rights, might you be foregoing those appeal rights?
So, and this is why I articulated the differences between the GLO and the HSS, is yes, you're absolutely right, as you mentioned earlier. By accepting the 75,000, you are waiving your rights to a future appeal. So you would call it delay, and I understand that. One of the reasons for delay on the 75,000 was we had to take a step back and say, well, actually, you know, how are we going to operate that in the HSS scheme? Because what we prefer to do is one communication to all the postmasters and past postmasters who had not applied to say, here is your opportunity to apply. Here is what the £75,000 scheme looks like. Here is a closing date. And here is the details of the appeals process. So if you decide to accept the 75, you are waiving your rights to this appeal process, and this is what it looks like. Now, because of a timing issue, and I have to say that the election was probably something to do with it, that appeal process was not built sufficiently enough to be able to be communicated. And therefore, all we can talk about is a future appeals process that is going to be built. But in my view, quite appropriately, we still felt we had to get out there with these offers. It's all about timely redress, because we're falling short on the timeliness of this redress. So therefore, it's not the best piece of communication. I accept that, to say, here is your top-up, here is your offer of 75,000. However, but by taking it, you are waiving your rights to appeal process, which isn't built yet. And I understand the optics of that. I absolutely understand the optics of that. And we have spoken at length to government about those optics. I call them risks. And the government are aware of our concerns around that. Nevertheless, everybody felt it's still appropriate to launch the £75,000 scheme accordingly.
So an individual may accept the 75,000 figure now in the knowledge that they are foregoing an appeals process that is not in fact yet developed.
Correct.
You've also addressed in your 8th witness statement the letters that have been sent out. You say 266 letters have been sent out to those whose applications have been recently received and the Post Office considers may be appropriate. 54 of those have already been paid. Can you tell us very briefly about the assessment? How have you assessed that certain current applications may be appropriate for that £75,000?
Well, because their claim, we've looked at that claim, and their claim appears to be under 75,000. So that feels like an opportunity. So we've ring-fenced that population, that cohort, and we've proactively gone out to them and said, would a 75,000 offer satisfy your claim? We've had a very interesting and a very prompt response to that, which is really encouraging. And we continue to do that with the existing cohort. And we've got a positive response back in many cases, and we turned around. So as soon as they sign their offer, they're presented with an offer. As soon as we pay within 10 working days.
Letters have also gone out to applicants who have received but who haven't accepted offers of less than 75,000. Is that correct?
Correct.
And there's also a mass mail out that either was just about to take place or has taken place.
We started it. It's up to 30,000. I can't send 30,000 out on the same day, but we are ramping that up. So we're at hundreds now. This week we'll send thousands. Next week we'll send. So we're ramping all that up to cover the 30,000 population.
To be sent to 30,000 people.
Circa 30. It depends on that. We're doing all the data analysis on the population. Yes.
Thank you.
So up to 30,000.
In terms of the top-up payment, those letters are also being sent out to those who settled for less than 75,000. Again, have they gone out? Are they about to go out?
They've gone out.
All of them have gone
yeah,
out.
and we've on that population alone, we've paid out 87 million.
And I think you've said in your 8th statement that 1,194 top-ups have been accepted. Presumably that's also increased since the date that that was written.
Yes.
And you've noted that 85% of settled claims have settled for less than 75,000. There might be a suggestion that those delays that we've seen in the process in 2024, you don't call them delays, but we saw the figures, the charts, the bars quite high as at the current period. It might be suggested that there is a delay being built into the existing claims in the hope that people will accept those £75,000 payments. What do you have to say about that?
I think that's fair. I think there has been an identified an exercise. I know there has been an exercise that's gone through on that population to say, is there a part of this population who you think will be appropriate to offer the 75,000, and therefore once we've got the funding in place, we can jump on that straight away. Absolutely, yes.
But do you think that has actually resulted in a delay to the processing of their applications through all the stages that we've talked about?
No, I think it's actually sped it up, if I may be so bold, because they won't have to go through the full process, the full legal analysis, the full HSF review, and the full panel session. So hopefully we go slow to go fast.
But those that are awaiting a panel session, for example, awaiting those various stages and meetings, is any consideration given to the fact that it might be that those are cases that will accept the 75,000, so we won't be progressing them to those various stages?
Absolutely.
There is?
Yes.
And can you expand on that, please?
So again, we look at the entire population that have made a claim, and if we believe, if the claim is for under 75,000, or we believe they may settle for under 75,000, we will approach them all to say, this is a new thing. Is this something that you would be comfortable with accepting, given that you'll be waiving your rights to an appeal, etc. And if you hear all the details, and if you're comfortable with this, let us know, and we will immediately make you an offer of 75,000. So they can interject into that process at any time they want.
Do you think that that is fair to those that are awaiting an imminent panel hearing, for example, or panel decision, that their cases might now go back slightly in the queue because you're waiting on the response to that £75,000 offer?
I don't think it's as timely as that. I don't think that would be a delay. And they have the right to continue with the process which they're on. We're not stopping that process. We're just giving them another option which they might want to consider. So I don't see that. And again, if they're queuing up for panel, and I actually see if they are prepared, if 75,000 is a good offer for them, I still would see that as being a quicker redress than going to panel and waiting the 30 days from panel to offer letter, etc., etc.
But just so we're absolutely clear, is there a conscious decision on behalf of the Post Office to not take forward those cases?
No. So only with their permission, only with the Postmaster's permission.
Could we please turn to Bays 40763? This is the minutes of a meeting with Minister Hollenrake on the 30th of April 2024. We can see there that you are one of the listed attendees. If we scroll over the page, please, there's a section on compensation. We have a couple of versions of this document. There's a slight change made to the minute, and I'll take you to that. But there's a discussion of compensation here. and it records as follows. Simon, is that yourself?
That'll be me.
Yep. Simon explained the message from us on OC2. Is that the new overturned convictions process?
HCRS.
Pardon?
HCRS.
HCRS. Happy to help. He noted that they are communicating with Charlotte and Carl's team, need to clarify within acceptable time about what that disclosure looks like. Full disclosure, big job and very expensive. Minister Hollenrake noted that he was hopeful that a lot of these people take the fixed sum award route anyway, and you say even to a place where no disclosure at all. And then this is the bit that is changed in the subsequent note. It says, how can I advise my client that £600,000 is good enough given no disclosure? The amendment in the later version, which I can take you to, says it's making clear that you're saying that claimants will say, how can I advise my client?
I'm trying my best to identify a risk that the government might face in terms of something that a legal advisor might say to them. How do I know that? How can I advise my client if £600,000 is a fair offer if I have no disclosure? I don't know.
Absolutely. I mean, this is not in relation to the current scheme we're looking at, but I just want to take you to some words from yourself within that meeting. So we have what you've said there, and it says, Simon said that they're hoping to help with capture, open and willing to let accountant in to have a look. Also, they are keen to see HSS appeals, that whenever it is ready. Minister Hollenrake says, still waiting for HMT, I think. Carl Creswell agreed with the Minister and noted that we're working with the Post Office to see if we can do the £75,000 top-ups, not new cases in the meantime. And that's the issue we've just been discussing, I think, in relation to the appeals process and the £75,000 offer. You say there, penultimate entry, Simon, current proposal on the new £75,000 is to do it in-house and not use the services of Herbert Smith Freehills. Is that still the case?
As in my statement and as advised earlier, yes.
Thank you. If we look at the amended version, that's Bayes 40764. It's not significantly amended, but if we look at the bottom of page 2, we can see there that the issue that you posed is, Kevin noted that he was hopeful that a lot of postmasters whose convictions are overturned by the bill will take the fixed sum award route away, and you respond even to a place where there's no disclosure at all, and this is the risk that you're highlighting. Claimant lawyers may ask, how can I advise my client that £600,000 is good enough given no disclosure? Doesn't that also apply to the £75,000 figure that we're talking about in relation to the HSS scheme? If your plan is for that to be a quick process, doesn't the risk that it's not going through that disclosure process, that it somehow bypasses that process, isn't that risk present here?
Yes.
Is there anything that you plan on doing about that risk, or is that just a risk?
I articulate that risk in a slightly different way, if I may. That is legal representation at the claimant stage, effectively. I think you called it disclosure. I say that it's legal representation at the offer stage, and I'm sure the inquiry have seen the documentation around this. Post Office have pushed hard on this with DBT. And I'm sure Carl will support that as well. The evidence is there. We've pushed hard on this in terms of wanting to have understanding the optics of having legal advice at the claimant stage from the perspective. DBT currently, their thinking is not aligned with that. In terms of funding that, everything has to be funded, of course, and it's taxpayers' money. In terms of funding that, and everything is under continuous review, but at the moment they're saying they want to stick to the current process.
So is your evidence that in respect of the £75,000 fixed sum offer or top-up, the Post Office's position is that it would be preferable to have legal advice at the early stage, whereas the Department for Business's position is different to that.
Look, I don't want to elaborate on a difference of policy between. That's not my job. Is to get redress out to postmasters as quickly as possible. I really cannot afford and don't want to get involved in sort of internal politics. But I need to answer your question, okay? And the Post Office's view has always been in this cohort that we should offer legal advice, to pay for legal advice in the offer stage, i.e., learning from our lessons from the original cohort.
You say at the offer stage, you mean prior to the offer?
Prior to at the claim stage, at the claim stage, and the evidence is there, and I'm sure the inquiry have seen it. The number of times I've written to the department to ask them to reconsider that position, and they haven't.
Do you know why? Is it purely funding? Is it something more than that?
I do believe, and I think I articulated before, I do understand. I try to be balanced. I understand that, so if somebody's got an offer, and people who talk to me regularly will be bored of me saying this story. If people have got an offer of 40,000 and they've settled and they're satisfied, I appreciate your definition of satisfaction is different to mine. They've settled at 40,000, and then they get a letter saying, we want to top that up to 75,000, sign here. I can understand why they may not need to necessarily think twice about obtaining legal advice. I get that. And certainly the process is not designed to encourage legal advice. And so, to make it simple and slick, fast, and get redress out the door, which is my job, I can see how that can work. I worry when the legal advisors come to me and say, hang on a minute, how can I advise my customer, my client, whether that is a full and fair? And that's a risk to me.
Yeah, thank you. That can come down. Thank you. Moving on to interim payments, you've addressed that paragraph 22 of your 6th statement. I don't need to go to the actual paragraph. At first, it was £10,000 limited to those in poor health or seeking or suffering from financial hardship. Is that correct?
Correct.
Those limits on availability were lifted in October 2022.
Yep.
And since July of 2023, interim payments of up to 100% are available to applicants who have received an offer.
Correct.
Does that mean 100% of the amount that you're offered, you will receive straight away, irrespective of whether you contest it further or not?
Yes, if you ask for it, yes.
Thank you. What is the situation in respect of those who haven't received an offer in respect of an interim payment? How is that calculated now?
So we do offer interim payments prior to offer, upon request, and particularly in hardship cases, but it's not limited to hardship cases. And we have a process where, as long as we've identified the shortfall, it's the amount of the shortfall we go up to that we can pay out. We don't get many requests for pre-offer interim payments. In fact, very, very few for pre-offer interim payments.
How is that now going to work with the £75,000 offer? If essentially people are getting £75,000 as of right, albeit risking certain rights such as appeal rights, does that justify a greater interim payment to those who contest the £75,000 and say that their claim is worth more?
So that's where the jeopardy comes in. And it's important that the inquiry understand that is that if they decide not to take the £75,000 offer, and subsequently their claim is gone through the independent panel, etc., and comes out at less than 75,000, they'll get the lesser figure.
And reflecting on it, do you feel that there should be or shouldn't be some sort of increase in the standard interim payment for those who are contesting, in light of the fact that they are contesting, but they have rejected a £75,000 offer?
Well, it depends if they've got an offer or not. So if they've got an offer already,
They get 100%.
yeah, I have strong views. As soon as an offer goes out, it's not Post Office money, it's not government's money, it's Postmaster's money. So as soon as that offer goes out, they're entitled to the lot. The dilemma I think you're articulating extremely well is the dilemma of when you haven't got an offer, the 75,000 has been rejected. So that's a pre-offer interim payment, and therefore we would go back to the shortfall.
Exactly.
Yes,
And
that's right.
looking at the £75,000 figure that's now going to be offered, do you think limiting those interim payments just to the shortfall figure is sufficient and is right?
I think it's consistent, and it supports the jeopardy that government clearly want to put in that place to say you've got an opportunity for 75,000, but if you don't believe that's sufficient, there is a risk that once the case has gone through the full assessment, the risk you face is it might be less.
Thank you. Could we bring up onto screen your sixth witness statement at page 56? And it's paragraph 167. I just want to understand some figures that are given there about interim payments.
Yep. Yep.
Thank you. So it's page 56, paragraph 167. You say there, in total, 474 interim payments have been paid to 312 applicants, 7% of applicants. Of these, Post Office have offered 174 single payments, equating to 100% of their offer, with the balance being partial payments, and 23% of complex applicants receiving an interim payment compared to 10% for standard applicants. Can you assist us? More interim payments have been made than there are applicants. Can you help us with that, please?
Yeah, absolutely. It is confusing, and our apologies, that is a confusing paragraph. An applicant can have a number of interim payments. So they may, even if they may have an offer, and they offer, let's say, is £100,000. They say, I'm going to go into dispute. In the meantime, can I have 50% of my offer? Of course you can. So we pay out 50%. They then may come back a few weeks later and say, well, actually, can I have another £25,000, please? Of course you can. You can have up to 100% of your current offer. Now, during the dispute process, for example, the offer might go up a few times. And every time that offer goes up, they're entitled to another interim payment up to that offer amount. So that's why there are more offers than cases.
Is there a number that you have for interim payment applications that have been refused? I think that 7% of applicants is referring to total applicants, isn't it? It's not referring to applicants for interim payments. Are there a large number, a small number, some...
Small, tiny
number that are refused?
I think, to be fair to them, again, a lot of these are legally advised, and the legal advisors understand exactly the process, and therefore they are advised absolutely appropriately.
And if we scroll down, we can see there in paragraph 168, you say, overall, 4% of those without legal representation have received an interim payment, and 64% of those with legal representation have received an interim payment. A very significant gulf between those who are legally represented and those who aren't. Again, that suggests possibly that the message isn't being communicated effectively to those without legal representation. What's your view on that?
I think that's always going to. I think that's a fair observation. I think the availability of interim payments is well known. It is on the website, etc., etc. So it is out there, and I know every case that goes into the dispute resolution process, they are all written to say these interim payments are available to you. In particular, around hardship, it's very clear that the interim payments. But I do understand we could always do more publicity and prompt it more. I do accept that feedback.
If we scroll over the page, please, we can see a chart there for the average days from interim payment request to payment. So that's the processing time of those interim payments. We can see even this year, it's nearly a 6-week wait from request to actual payment. We've seen again the number of applications increasing. That's something we looked at earlier in terms of 2024 figures. What gives you confidence that it'll either stay the same or reduce?
As advised in my statement, we are going to adopt much of the automation and the efficiencies around the £75,000 process. This will come down significantly.
I won't take you to our expert report again, but it's page 58 of that report. Lots of red again in terms of satisfaction levels with the interim payment process. I assume your answer to that is the same as before, that you understand it and something you recognise.
And disappointed.
Yes. Returning to legal fees more broadly now, if that can come down, please. The BAT, below assessment threshold cases, are they provided with any legal advice?
So they are made an offer, and therefore at the offer stage they can still have a legal advice. They're all the same.
Are you aware of what kind of proportion of those cases actually take legal advice?
No, I'm not. But of course that has now been taken away by the 75,000.
Yes. You've explained the background to why legal fees are only available at the offer stage, or why that was formulated. Previously, there was £1,200 for legal advice, where the offer was less than the sum claimed. Is that correct?
Yes, that's right. Yes.
And there was a small amount, only £400,
yeah.
for where the offer was for the entire sum or for more. Those caps were removed from all offers made from the 10th of October 2022. Is that correct?
That is correct.
Applicants are now entitled to what's called reasonable legal fees. Is that different to legal fees available in the GLO scheme, where there are fixed sums for legal advisors?
We try and work collaboratively to the ranges in the GLO, and we have used those, yes, but we still base ours on reasonable. So there have been a number of occasions when, and I have been given authority to exceed whatever reasonable is, but I take legal advice on those. So we are still, we do use the GLO guidelines as guidelines, but there we are still we have reasonable fees.
If we could go back to your sixth statement, please, and turn to page 10. Paragraph 27, you give figures for the average legal fees. Maybe quicker if I just read it. It says the average legal fees prior to the 10th of October 2022 was £3,044, and after that date it was £4,575. Can you assist us with that difference, why you think it is that those figures have changed?
Just the submissions from the legal advisors. That's I'm very comfortable with them.
If we could please turn to page 66. Paragraph 184. Thank you. We see there that the take-up of legal representation is low, 12%
Yep.
in respect of those who have had offers, 16% if you include legal support rather than legal representation. Why do you think that take-up is low?
I really don't know.
If we go to page 63, please, paragraph 181. If we scroll down, you say there that in almost all instances, a legally represented applicant receives a higher offer, even within the same applicant types.
Correct.
Can you see an issue there?
I don't care. Absolutely.
And what's the issue?
Well, claimants are generally, the vast majority are not taking up the offer of free legal advice funded by the Post Office. And yet the stats are clear that when they do have legal advice, they get higher payouts. I absolutely understand that.
If we go to page 64, there's a table. And we see there in 2024, for example, in complex cases, similar in 2023, it's almost double the figure where those individuals are legally represented. Is that something that you were aware of before compiling this chart?
I think this makes it much more transparent, but yes, I was aware.
Yes. Does that in some way suggest that representations, further pushing from people representing individuals is necessary, and that actually the Post Office on its own isn't coming up with the right figures?
I wouldn't call it pushing, I would call it representing.
And why should that be necessary? To drive the figures up by, in some cases, double?
Because they're representing their clients, and their clients are providing a position for them which they are asking to be represented. I do see it as an issue. Again, in my mind, I struggle with this. I absolutely get it, and that's the reason, one of the major reason why Post Office recommended, following Sir Wynn's prompt, around an independent appeals process, where people, if they feel dissatisfied, now they see these statistics, the transparency that this is provided, and thank you for doing it, actually, do they feel they have an unfair offer? Subject to Sir Wynn's challenge around, well, what's the parameters of that appeal? Who qualifies for the appeal? If, in the way that I've articulated to government, and government, have accepted this, is that if they believe, and the advisory board more importantly have said this, if they believe they've had an unfair outcome, and seeing these stats, they may feel they've had an unfair outcome, then they have the option for the appeal process.
One thing we spoke about earlier was legal advice at an early stage. In the GLO schemes and the overturned conviction schemes, we understand that solicitors can commission a report, such as a forensic accountant report, from the outset. Might that, first of all, speed up this process, and secondly, as you've highlighted, have an impact on the final figures? And why do you think there is that difference of approach? I
think there is an aspect of trying to keep this as legally light as possible. I understand that. A lot of the feedback, in fact, I noticed in the YouGov survey as well, there's a lot of feedback about this is too legalese. Why can't we just cut a deal on this and make it a much more simpler? I get that from many of the legal advisors as well. Why do we have to go through this process? Why can't we go into and just shake hands on things? So I think I'm not trying to counter it, because I'm absolutely agreeing with you, but I think there is this other aspect still that I still grapple with about how can we make this as simple and as unlegalistic as possible. Thank you.
Before we take our afternoon break, I'm going to take you to that letter from Dr. Hudgell that we've spoken about. It's HUJ, I think it's 6 zeros and then 7.
This is the new bundle, yeah?
Yes. It's a letter of the 23rd of October of this year. So a very, very recent correspondence between yourselves. Thank you. The letter includes various examples of the differences between original offer and revised offers. If we scroll down, please. These are in respect of those who Dr. Hudgell represents. We see there at number 2, for example, the original offer 46,000 in December 2021, a revised offer of 140,000 by November 2022. Number 4, we see from £4,000 in the original offer to £133,000 within the space of, it's taken 2 years. The original offer July 2022, the revised offer September 2024. If we scroll over the page, number 8, we have there an original offer of 363,000 and revised 2 years later to 649,000. Very significant increases in these figures. Number 11, 298,000 to 421,000. 13, 260,000 again to 420,000. So quite similar increases in those 11 and 13 from 200 to 400,000. Do you accept that there are big changes in these offers and the revised offers?
I absolutely accept them and think it's great.
Number 9, we see there the original offer 42,000 in August 2022, 45,000 by May 2024, and we understand that that now stands at £171,592. So a dramatic increase, despite the fact that that figure not really changing very much between 2022 and 2024. What's your view on that?
My view on that is that the legal advisors are doing the excellent job that they do, and they are gathering the information required for enable the panel, in many cases, if not Post Office, to increase the offers based on the evidence that is provided with the help of the legal advisors, maybe by forensic accountants, by medical reports, etc., etc. So I think the legal advisors are doing exactly what they should be doing and doing a brilliant job at it.
Isn't something going a bit wrong, though, that there have been such dramatic leaps in those figures, taken so long to negotiate?
So I think there are two separate issues here. In something going wrong, no, it's going right, because the evidence is being found in order to increase those offers to get to the fair redress. Timeliness is a separate issue, and I accept that challenge about how long it's taken. But and you know, this is a two-way street here. That we like to work collaboratively with the legal advisors and make it clear to them what would help the case. Many of these cases, of course, all the cases have originated from the independent panel. That's where the original numbers come from, and many of these cases go back to the original panel. So again, they work within their terms of the panel work within their terms of reference to come up with these new offers. So they are basing it on evidence that has been produced by the postmasters and the legal advisors. So this is a process taking too long, but it is working.
It's working for those who are, in this case, represented by Dr. Hudgell and represented by others. But if we can turn back to the YouGov report, that's EXPG 607, and if we look at page 52 of the YouGov report, it addresses legal advice. Page 52. We have there only 33% of respondents said that they had been informed of their right to obtain legal advice. Only 10% were provided with information about how they could contact a legal representative. If we look at the bottom of page 52, the author says, reflecting the low awareness of the right to obtain legal advice, just over 1 in 8, 12%, actually received legal advice during the application process. Amongst those that did, 11% received financial support that they felt was sufficient, but 63% did not receive financial support. And we can see the chart over the page, please. Actually, if we turn, yes, figure 39, received financial support for legal advice during the application process. Overwhelming majority didn't, and that's reflected in your own figures. If we go, please, to page 55, even in respect of those who received financial support for legal advice when they received their offer, you have there 29% saying no financial support received for legal advice when they received their offer. There is a net yes, but 23% of those felt that the financial support was not sufficient. Looking at these and looking at your own figures and looking back at that letter from Dr. Hudgell and the impact that lawyers have had in that particular case, and I think you've really already given your evidence on this, but do you think that something's going a little wrong there in respect of the availability, the take-up of legal advice, and the impact that it may have on those who may have received offers or those who are awaiting offers?
Well, I think the first sentence is on page 52 of the YouGov survey. It says 1 in 3, 30% recalled having been informed of their rights. So that's their recollection of being informed about their right to obtain legal advice. The evidence which the inquiry would have seen is that everybody is offered legal advice at the offer stage. So this is, now, again, I don't want to project this sort of corporate image because it's not a corporate image. It genuinely is not. But the offer of legal advice is there at reasonable costs. I haven't turned anybody down in terms of the amount of legal fees. I've had the odd discussion with legal advisors about their bills, yes, but we've never fallen out about it. And so the offer is always there. It's the take-up is the issue. And I think the challenge, quite rightly, from the inquiry should be how much have you pushed the fact that the benefit of legal advice. That should, maybe that's the challenge that I should go away and consider, because it's clear from the stats, as I've said earlier, my evidence is my evidence, is in that there's clearly a benefit of it happening. But to be clear, the offer is there.
And how do you think you can improve that situation?
By being more upfront, as more I possibly can, by making sure the clients are yes, they are my clients. My clients are aware of that opportunity. Again, I still struggle. I've got an 83% acceptance rate. I need to grapple with that. And where people appear, I'm not going to use your word anymore, they appear to want to settle at that rate.
Thank you. So that might be an appropriate moment to take our mid-afternoon break.
Yeah.
Could we come back at 20 to 4, please?
Certainly, yeah.
Thank you. Thank you, sir. Mr. Recaldin, my last question in relation to the historic shortfall scheme concerns an end date. When do you expect it to close? Is there a date fixed? And has a date been publicised?
Expectation, don't know. Is there a date fixed? No. There has been discussions prior to the election about when that date might be. And we did propose a date, which was sort of tentative. Nothing's been agreed, nothing's been accepted, but it was understood when that date might be. But then, of course, we had a peak of late applications, etc. So the date that was originally discussed was actually March 2025. And we've been advised by government that might still be being considered, but let's not take that as a date that will be publicised. So yet to be determined.
And is that a date for potentially the application process to stop or the entire scheme to finish?
Applications to be in by.
Thank you. One thing that you've mentioned is the Postmaster Contact Centre. You've addressed that in your witness statement. You say it opened in September of this year. Can I clarify, is that simply for the HSS scheme or for all schemes?
It's for whatever the postmasters want, so it will be for all the schemes. Currently, it's predominantly to do with HSS because that's the incoming, but we also mandate outgoing calls as well to be helpful and proactive. In the fullness of time, it will absolutely be anything we can do on the OC side as well.
And what steps have you taken to publicise that contact centre?
It's available on the website and available via correspondence.
Would it surprise you that some sub-postmaster corps participants were not aware of this centre until receiving your witness statement?
It wouldn't surprise me at all.
In light of that, is there anything that you have in mind that you could do to publicise it more?
So in the mass mailing, which we've currently started, is absolutely included all that. So there will be huge publicity because of the up to 30,000 letters that are going out is included in that. And they all point to the website as well in terms of where that number is available, including, and also any outbound calls, they are effectively publicising their availability to take inbound calls as well.
Thank you. I'm going to move on now to the overturned convictions redress. It's not known as, internally at least, as the overturned convictions scheme. Is that correct?
Correct.
On the 11th of December 2020, the first 6 convictions were overturned by Southwark Crown Court, and then the Hamilton judgment was on the 23rd of April 2021. By the 22nd of August of this year, you say in your 7th witness statement, I think, 111 appellants had successfully appealed their convictions and therefore fell within this scheme. Is that correct?
That is.
And they fall within this scheme and not the historic shortfall scheme because, as we saw in the eligibility criteria, it doesn't include those with convictions.
Correct.
There is, however, another category also included in this redress. I won't call it a scheme. What do you call it if you don't call it a scheme?
Process.
Redress process. And that is those who were prosecuted but not convicted and who aren't postmasters and therefore also fall outside of the historic shortfall scheme. Is that right?
Correct.
What about those who weren't prosecuted but who received cautions?
They are included in that cohort. Prosecuted, not convicted, they are within that cohort.
Thank you. So not convicted extends not just to those who had a trial, but also those who simply received a caution.
Caution, correct.
In terms of government funding, you've said in your witness statement that became available in July 2021. Was that difficult to obtain?
No.
That led to interim payments of £100,000 at that point in time.
Yes.
Or from that point in time. And then there was a second funding agreement in December of 2021. Again, was that difficult to obtain?
I wasn't around, so I don't know, but my understanding was it followed the process and it was put in place.
Could we please turn to poll 00448-914? as you say, this is before your time, but this is the funding commitment as at 22nd of July 2021, communicated by the Department for Business, Energy and Industrial Strategy, as it was known then. If we scroll down, please. It says the funding commitment letter confirms that the Department for Business will provide funding for Post Office to make interim compensation payments of up to £100,000 to each postmaster, branch manager and/or assistant who have their criminal convictions overturned by the Court of Appeal or the Crown Court due to unreliability of evidence obtained from the Horizon IT system operated by the company. Over the page, please, it sets out there the funding structure. And it says each interim payment, which shall be no greater than the aggregate of £100,000 per any one affected postmaster, will be eligible for BAYS funding to the company, provided the postmaster meets all of the following criteria. One, their Horizon-related conviction has been overturned by the courts, and that's why we see the scheme doesn't involve those who recently received the change following the legislation. Number two, they do not belong to the class of postmasters whose convictions were overturned but were not opposed by the company on public interest grounds. Now, at this stage, that was an additional criteria, that it couldn't have been any of those cases that weren't opposed by the public interest on public interest grounds. Can you briefly explain your understanding of that?
So, public interest cases, and there are five of them. So these are cases that go to the Crown Court at Southwark, and when the case is made to it's a quirk almost of the Southwark Court, in that the cases that go forward, you can either support the appeal, or you can the alternative is a retrial, and clearly a retrial is not in the public interest, and therefore by default you are going to a case where there you are supporting the appeal of the conviction, or you're raising no evidence against it.
And in those cases were originally not included in the scheme, but they are, I think, since following the Mr. Bates ITV drama, there was a change in that position. Is that correct?
There was a journey to get there, but yes, that is correct.
When you say a journey, what was the Post Office's position?
Because of this funding agreement, even though those three cases that I mentioned earlier, their convictions were overturned, but because of the funding arrangement, they couldn't be paid their £100,000. So despite Dr. Hudgell asking for it, the funding arrangement will not allow us to do it. So you've got cases which have been overturned by Southwark Court, and yet, because of the funding arrangement, they weren't entitled to their £100,000 because technically they weren't Horizon-related cases. And that was an awful position to put anybody in. And so we had to work our way through that, and we went through mediation to do that, and we reached settlement with two of them. Subsequently, due to the debates and the mass exoneration, those cases have now been reopened and now back in OC.
So I think you said there were 5 individuals. What is the current status of those cases?
All those 5 are within the OC. I think one of them has been settled.
Thank you. Could we please turn to poll 004489115? This is the second letter of 20th of December 2021, and it's the funding commitment letter that confirms the department will provide funding of up to 685 million to the Post Office when aggregated with the funding committed under the interim payment funding commitment letter. The total funding amounts to 780 million, and then it sets out below the criteria. So those who have their criminal convictions overturned following the common issues and Horizon issues judgment issued in the Post Office group litigation and or the Hamilton and others judgment issued by the Court of Appeal, or were prosecuted but not convicted of offences connected to the Horizon IT system and suffered detriment in respect of the actions of the company. Am I to understand, therefore, that that has now changed and we should add to that a third category of those who received cautions? Because they wouldn't have been prosecuted but not convicted.
My understanding is cautions are included.
Are you aware of any formal change to any agreements in that respect?
No, I'm not.
If we go over the page, please, to the bottom of the second page, it says there, the department has agreed to fund the claim payments made by the company to fulfil BEIS's commitment to delivering compensation to postmasters fairly and as quickly as possible, and supporting and maintaining the post office network. It continues a couple of sentences on. This funding commitment letter specifically covers the provision of funds for claim payments for the OHC liabilities only, and is provided to support the company in delivering its rescue and restructuring plan. Can you assist with how the redress for these cases relates to supporting and maintaining the post office network or the rescue and restructuring plan?
I'm sorry, I can't help you there.
That can come down, thank you. Let's move on then to interim payments. Interim payments under this scheme were introduced in July 2021, as we've seen, for £100,000. They were increased to £163,000 in November 2022, following representations made by Lord Dyson, who was carrying out the early neutral evaluation, which we're going to come to. Is that correct?
Yes, it is.
More recently, it's increased for those who don't seek what is referred to as a government offer, and that's the £600,000 payment, which we're going to come to as well. It's been increased to £450,000 as an interim payment at the request of Sir Gary Higginbottom. Is that correct?
That's my understanding.
You've set out in your seventh statement, paragraph 122B, that the average time between submitting interim payment applications and the payment is 34 working days. Is that correct?
That's my recollection.
So let's look at the government offer. Since the 18th of September of 2023, there has been an offer of £600,000 to all overturned conviction claimants. Is that correct?
Correct. Correct.
Correct. That doesn't apply, though, to those who are prosecuted but not convicted. Is that right?
That is right.
Can you assist us with why there is that difference?
Because the difference is the actual conviction.
In respect of the rights, and we spoke about this in respect of the HSS scheme, am I right to say that the £600,000 is only available to those who don't seek a full assessment of their claim?
Correct.
You've said in your seventh statement that by the 31st of May of this year, there were 40 accepted cases. And you said that the average length of time from receiving the offer to payment is 20 working days. Is that all correct?
Yes, that's right.
Pardon?
Yes, sorry.
Thank you. Could we please turn to BEIS 0000719, please? 40719. This is an email chain. I want to ask you about your initial views as to the £600,000 government offer.
Yep.
If we turn to page 4 of that document, the background is, I think, that Herbert Smith Freehill have drafted a letter relating to the £600,000 figure. Is that correct? Or a letter has been drafted by somebody. If we scroll, please, to page 4, we can see some of the background. Do you recall this chain where you're commenting on a statement that's being made in respect of that £600,000?
I recall, I saw this email the other day. I do recall the email. I recall its construction. I cannot recall as a result of a letter.
Well, perhaps we'll go through it in a bit of detail. If we start where we are, this is a email, if we scroll up slightly, from Emily Snow, who is a member of the Post Office compensation team in the Department for Business. And she says as follows. She says, you'll spot comments in both attachments on pitching as a DBT-only intervention. I appreciate that it is a DBT proposal and that the timescales at which we're working have meant that we haven't been able to do the type of engagement and ironing out of issues that would have been preferred, not least by the Post Office. However, I'm somewhat cautious about the language, which goes quite far to pitch as a DBT proposal without showing some interaction between the Post Office and the department, as you'll see in the core text. This is from a view that we don't want to create a perception that the government is stepping in because it has lost faith in the Post Office process. This is not the case at all. We should send a positive message. There are two good options for postmasters, £600,000 or remediation, which the government supports, since postmasters who do not wish to accept the upfront offer will still need to go through the remediation process. I think the wording should uphold the faith in that Post Office-led process. There's then a response, and we see there, it's the email below from Neil McDade that says, by way of an update, Herbert Smith Freehills have crafted a high-level heads-up letter to claimant representatives, which the department have commented on. They've also provided comment on the core lines to the Post Office. And it's above that that we see your response. And it's that response that I'd like to talk to you about. You say as follows, you say, care with the statement, please. You're absolutely right. This does read as a DBT proposal without showing interaction between the Post Office and DBT. As apart from you and an email exchange between myself and Carl, that's, I think, Carl Creswell, initiated by me, there hasn't been any. Of course, will create a perception that the government is stepping in because it's lost faith in the Post Office process, as this is precisely what it is. I don't think we should be disingenuous. We have to be honest and transparent here. It's clear from this and the lack of risk assessment to the Secretary of State that the government nor the advisory body have any faith in Post Office. This will come up at the inquiry with government nowhere to be seen. The paragraph of most concern I have lifted and pasted below my comments in red. If we scroll down, we can see you've lifted a paragraph from this statement and commented on it. So it was going to say government having consulted with Post Office, and your feedback is false, delete. Only you have kindly told us the bare essentials, and then to a highly restricted audience, this is not consultation. It then was going to continue, has decided that postmasters who have their convictions on the basis of Horizion evidence overturned should have the opportunity up front to accept an offer of £600,000 in full and final settlement of their claim. This will be delivered by the Post Office with funding from the government. And your comment there is, this implies this is extra funding and again is disingenuous. This is not extra funding, as you know. The funding is already in place. It's just a different, hopefully more efficient way of paying it out. In fact, a quick look at the Post Office accounts will show to anybody who wants to see that we are anticipating in paying out in excess of this average. This is where consultation would have helped. Just pausing there before we continue with this, can you assist us with your position as set out there?
Yes.
Please do.
So I think the 600,000 opportunity was brilliant. I think it was an inspired idea in terms of how to speed up redress. It was, I think I'm clear in my note, it's the way that it was imposed on Post Office, and yet we were told that it was clear in the correspondence that they had consulted with Post Office. Government had not consulted with Post Office. My statement is clear. I was told about it literally in a quarterly shareholder meeting we had I was advised that it was going to be launched the next day. I knew about it probably 24 hours before then, because I did request DBT whether or not we could see the press briefings around it, and I think I was politely declined that as well. So it was all shrouded with secrecy in terms of its actual launch. There was no, but Post Office were expected to operationalise it, manage it, and push it through. So, and that came out in my note. There was no consultation, which can be fine. It doesn't mean to say it's not a good idea. It's still a good idea. Don't get me wrong. And it came directly from the Secretary of State, and that was one of the reasons why we believe that it was confidential, etc., etc. It was kept under wraps because it had to make an impact,
And
a positive impact.
why do you raise a concern about the extra funding being disingenuous, or reference to extra funding being?
Because the impression that was given by the statement was that government had proactively found additional funds in order to be able to do this, and that was not the case. The funds, as I articulate, the funds are already available. It's just a different way of doing it.
Thank you. Do you have a similar view in respect of the budget announcement that's just happened in respect of the extra funds?
Forgive me, my job is to pay out redress as fast as I can, and I know I'm being challenged on that, and as much as I can. I really do not, my preference is massively not to get involved in politics with a small p and a large p. But I have to answer your questions. And there are elements in this, and there are obviously elements in the Chancellor's thing that are political. And I find myself in a really, really difficult position around that, because the politicians with a capital P are taking the opportunity, and that's their right, they're politicians, that's what they do, to take advantage of that, to I don't know what, to give themselves publicity, to give themselves credit for whatever. This 600,000, to your point, is a Secretary of State decision.
Thank you. We'll move on. You say, I suggest we change to government has decided that postmasters who have their convictions on the basis of Horizion evidence overturned should have the opportunity up front to accept an offer of £600,000 in full and final settlement of their claim. You say, I think this is damaging enough and is a bit more like the truth, please. I think somebody has to try and cling to some morals here, please. This is an imposition, and it should not be flowered up in any other way. The Department for Business, the Secretary of State should take the credit for this initiative. Let's not forget that this will be exposed at the inquiry, where this will be seen for what it is, a clear political intervention into a post office scheme with good/excellent intent, but simply not thought through, which is how the legal representatives will view it. Interestingly, despite the common interest and direct request, Post Office have yet to be extended the courtesy of seeing the legal advice given on this, on the scheme we have to run. Does any actually exist? What do you mean by simply not thought through?
So, the allegation that we were consulted, the Post Office were consulted when we weren't, and part of not thought through was we immediately started asking questions around what does this 600,000, is it a minimum payment? And it became apparent it wasn't a minimum payment. Oh, right, okay, so how are we as the operational people going to administer this? And there were questions that we were posing that had yet to be worked out what the answers would be. In addition, with the greatest respect to the legal representations in this room, is that I had a couple of phone calls from them wanting to understand. And to my point about the politicalisation of this, I got 2 calls from legal representation sitting in this room before I was advised of this scheme to say, this is about to be launched. What's your comment on this, this and this, please? How is this going to work and how is this going to work? And I'm afraid I had to say to them, I don't know, because I'm not aware of this scheme. I'm not aware of how we're going to operationalise it. Bear with me. That's embarrassing. Bear with me. I will come back to you as soon as I know the answers. So that's where that comes from. And there was some publicity around this, because effectively that population out there of convictions, it became immediately apparent that the spin on it was that everybody was going to get a minimum payment of £600,000. We had direct approaches from very distressed postmasters that because the people knew they were in that cohort and that they knew they were making a claim, they were going to get £600,000. And we did have reports of people actually knocking on their door about it, and that was quite distressing. And I got that feedback through the legal advisors as well. Do
you mean that they were concerned for their safety or for being chased for money from third parties?
To that point, the vast majority were anonymous. And yet, if anybody knew they were making a claim or part of the scandal, then they knew that effectively this was saying that they're going to get a minimum of £600,000.
You continue. For your information, we have had a pecuniary claim in from Hudgels at the end of last week for £18,000. Their non-pecuniary was settled for £195,000. Under this proposal, this individual will enjoy £600,000. I'm not saying this is wrong, and you know I want to pay out these sorts of sums, but to date have been prevented by value for money restrictions, evidence, governance, etc. Just pausing there. Now, you addressed value for money at the very beginning of your evidence today, and you said that you didn't think that value for money restrictions were being imposed in respect of the settlement of compensation claims.
Yeah.
This reads somewhat like it did have a role.
Yeah, I could understand that it's not meant that way, but it's a list of processes, restrictions that I had to go through and governance that I had to go through. I do understand your point about, but no, please, value for money is not applicable in this.
You continue, at a stroke, all credibility/professionalism is gone. Never mind the months of work put in by Post Office and DBT on principles and working with postmaster lawyers. The inquiry will see all this. I have to assume all are comfortable with this. I'm not. It might be suggested that what you're saying there is you're not happy with the £600,000 scheme because, for example, in that Hudgels case, the Post Office could have got away with a lot less. What's your view on that? No,
I think that's the wrong interpretation of that. I've been clear in the paragraphs above that I think this is a good idea and this is exactly what I want to do. I think I can argue that sentence is more around the process that you have implemented, that you have agreed that I can follow, the governance that you have put in place for me that I have to follow, only allows me to pay out this amount. And yet, at a stroke, you're completely undermining that and saying, actually, you're going to get £600,000.
You say, am I the only one worried about all this? Is it me, or is this really Emperor's New Clothes stuff? I think we're sleepwalking into real difficulties. What did you mean by that?
Again, it's around these Post Office are an operational engine that delivers these outcomes, these fair outcomes. At a stroke, the government were undermining the confidence in that it says in here by saying that actually, effectively, we're uncomfortable with this process, and it's clearly not fit for purpose because it's not paying out enough, and therefore what we're going to do is we're going to impose this on, and we're not even going to consult about it.
Could we please turn to Bays 40738? And now moving to January of 2024, and there's an email chain regarding whether it's a minimum payment or not a minimum payment. If we start on page 4, we see at the bottom of that page being forwarded to you an announcement from the government announcement, re-overturned convictions. Once this legislation is passed and convictions have been quashed, individuals will be entitled to at least £600,000 in compensation to rebuild their lives. The government has always been very clear previously that there's no minimum amount, although in reality the £600,000 up front offer set that floor. If they're saying publicly that individuals are entitled to at least I think that should be £600,000, it feels uncomfortable to me that we cannot make interim payments to that amount. Now, is this the overturned convictions process, or is this the other process.
So this is the new process from the £600,000 that effectively wasn't. So in terms of interims, we couldn't go up to the 600,000. It wasn't a minimum payment. It was very clear, to be fair, very clear that this was for full and final settlement only. So it's a bit like the 75,000. Here's £600,000, providing you are prepared to settle.
And if we scroll up, we can see correspondence between yourself and Carl Creswell. And you say, I know we're going through interesting times. Is that a reference to the post-Bates television drama? We're in January 2024.
Yes.
But further to previous mails, does not the government link below translate to the current 600,000 being a minimum payment? If so, we could pay circa 60 cases up to £600,000 with imminent effect. And if we scroll up, the response to you is the £600,000 is a fixed offer sum that postmasters can choose to take, or they can seek to make a fully assessed claim. It is not a minimum payment sum and therefore not suitable for an interim payment amount. There is a £163,000 interim payment to relieve any immediate financial pressures for those making full claim whilst that claim is developed and considered. Additionally, specific further interim/hardship payments are also considered if requested by a claimant. If we scroll up, you say, okay, Beth, okay, last go, I promise. I do understand the initiative, but it's not logical. We do need to, we do not have an expiry date on the £600,000 full and final offer. We await to hear on this. So currently there's no expiry date on this offer. If a victim decides to push their claim through full evaluation and their offer is less than £600,000, they'll be advised to take the £600,000 in full and final. If their offer is above £600,000, they clearly will settle above £600,000. So whatever happens, they get £600,000 as per the mass exoneration scenario, nicely aligned. So whatever happens, they get £600,000. So alleviate postmaster stress and media outrage by being proactive and topple 60 up to 600,000 because they're all going to get that anyway. If we scroll up, the response to you is you asked yesterday whether the aim was to get money as quickly to claimants or to get full and final settlements to the claimants. Our focus is on achieving the latter. This proposal doesn't encourage any pace or movement to full and final settlements, does it? Ministers and politicians, as shown in the Select Committee, are keen to take steps to encourage victims getting their full and final settlement as quickly as possible. I don't believe this moves the dial on that. You respond, slightly above. Beth, so we hold the funds back that we could pay to encourage full and final. No need to respond, but grateful for your two responses. Last word, promise. What is the right thing to do? I've moved on. If we scroll up, we can see the response. The policy position regarding the 600,000 was announced by the Minister last year. Last week's announcement doesn't change that policy. You asked yesterday whether you should focus on maximising payments or maximising settlements yesterday. We were very clear that we would like you to focus on ensuring that claimants are able to settle their claims as quickly as possible, as this is what ministers and other politicians are keen to achieve. We need to ensure that victims can complete the claims process. The proposal that you have made does not speed up the overall claims process and indeed may actually further lengthen it. That is not fair to those who are still waiting to achieve full and final compensation, many of whom are coming up to their third anniversary of their conviction being overturned this spring. Can you assist us with this, what appears to be a dispute between the Post Office or yourself and the Department for Business?
I can. So, and it's pretty clear from the one below from the department around, there's a choice here between are you saying the objective is full and final settlement? Is that a priority over paying funds out? Because in particular in OC, there are many opportunities, as I explained earlier, to pay out more further interim payments. And what the department was saying to me was, no, we don't want you to do that. That's not the aim, that's not the objective anymore. We'd rather you hold on to those and hold out for settlement. I was extremely uncomfortable with that, and I think I'm making my point articulate what is the right thing to do, because I didn't want to delay redress. It seemed to me that I was getting an implication to delay redress in order to hold out for full and final settlement. I was saying, hang on a minute, I'm not quite sure I'm comfortable with that. If I've got the opportunity to still pay out redress, a bit like my example, if there's an offer there, I want to pay the offer amount, then I don't want to feel restricted about not paying that out because I'm only going to pay out when I get a full and final settlement. That for me was quite a strong moral dilemma. And maybe I articulated it badly in there, but that was the moral dilemma that I was facing. And they made it clear to me, absolutely crystal clear, no, Simon, the objective is there, black and white, full and final settlement. So I then had to issue instructions internally to say those potential interim payments, government will not approve them now. And they didn't approve them because we were holding out a full and final settlement.
And what is the latest position on all of
It's
that?
changed.
How has it changed?
So government now appear comfortable that whenever we can make payments via a head of loss, for example. So there may be 10 heads of loss, and we make the legal advisors and we may be comfortable with 8 of them. We can pay those 8 heads of loss, and we settle effectively via each heads of loss.
Does that extend beyond £600,000 potentially?
Can do, yeah.
And when has that change been in place?
Forgive me, I don't know when, but for some time. But this was the initial, and since then the position has eroded.
But can you give us an idea? Was it in the summer, in spring? This is January of this year.
Yeah, this would have been during the summer. Yeah.
Thank you. Moving on then, that can come down. Thank you. Moving on from interim payments, there's then a full assessment for those who don't opt for the government offer.
Yeah.
Claims are made of pecuniary, that's financial losses, and non-pecuniary losses, such as physical and mental loss impact. Let's start with non-pecuniary. You've addressed this in your 7th statement at paragraph 100. You describe the early neutral evaluation scheme that was set up in 2022. Lord Dyson was appointed to the role of evaluator, and he evaluated at that point 10 claims. And this led to Lord Dyson's evaluation of the 29th of July 2022, which set out the ranges of redress for various heads of claim. Is that correct?
Correct.
Lord Dyson considered matters again in December 2023 relating to whether the money from the group litigation order should be deducted. Can you summarise for us what his finding was in that respect?
Well, nobody should deduct the GLO payments that ought to be made from redress.
Do you know what the Post Office position was in respect of those GLO payments prior to that decision?
That we were deducting them.
And were you in favour of deducting them, or was there an internal discussion that you were party to as to whether that was the right or wrong thing to do?
I was aware of the policy, the process to do it. I wasn't involved in any debate about whether to do it or not. It was just accepted that their overall redress would be discounted by the redress that they'd already received.
Thank you. The Post Office, you say in your statement, has offered to refer 3 further cases to Lord Dyson for his own review, but that hasn't occurred. Can you briefly assist us with what that involved and why it hasn't occurred?
There are 3 specific cases. Forgive me, I think they all come from one legal advisor, and we are very, very keen where the legal advisor is not agreeing with the non-pecuniary offers that we are making. And in order to resolve those, we have suggested that we go back to Lord Dyson to help us evaluate, and we are extremely supportive, and we are trying to encourage that proactively. And as yet, we haven't managed to get the time in the diary from the legal advisor's perspective.
And is that something that Lord Dyson is happy to do?
Yeah, absolutely. We've even had previously time in his diary allocated to it.
Paragraph 75 of your 7th statement, you say that by the 28th of August of this year, 77 non-pecuniary cases have been fully settled, including some who accepted the government offer. Is that correct?
That's right, yes.
I think you say 77 non-pecuniary, 9 non-pecuniary haven't settled, 25 more expected but not yet submitted. Perhaps we can bring that onto screen. That's the 7th statement, so WITN 09890700. That's paragraph 75. That's page 27. Thank you. So that gives the figures there. 77 non-pecuniary claims have been fully settled. You also say in the statement that over 90% of non-pecuniary claims submitted were settled and paid within 44 working days of application submission. Is that right?
That's right.
It appears from your statement that the non-pecuniary cases that take a longer time is bankruptcy cases. Is that right?
Yes.
So whereas in the HSS scheme, I think you weren't particularly concerned about the bankruptcy cases and delay. Is there a concern there at the moment?
To be clear, for the inquiry, I am always concerned in any delay, firstly. And again, where the bankruptcy is involved, we just have to engage with a third party, and therefore that elongates the process, builds in delay.
And is there anything there that you think would speed up that process?
I think we're on this, and there will always be things we can do to speed up redress, and if this is one of them, I'm more than comfortable to get involved. But at the moment, it's not being raised to me as a significant risk.
Thank you. Moving on then to pecuniary, you've explained that prior to establishing the pecuniary principles, it was a slow process. Is that right?
Yeah.
Those principles were established in October 2023 and finalised in January of this year. Is that right? We saw that non-pecuniary claims took an average of 44 days to complete. In terms of pecuniary claims, you've said 305 working days. So over a year in relation to pecuniary claims. Is that your experience?
Well, in terms of, but that my understanding is that will be including the building of the pecuniary principles. So that was a journey. So when, and I think Mr. Cameron's witness statement also sort of supported this, when I first arrived at Post Office in this space, obtaining settlement with postmasters on overturned convictions was a negotiation. Okay, it was locking lawyers away in a room and working things out on a heads of loss by heads of loss basis, and it wasn't constructive and it wasn't collaborative. And so the first thing I did, and Mr. Cameron's evidence sort of supported this, was I proposed a different approach, a remediation approach, very much a collaborative with the postmasters and their legal advisors to walk in the journey between us, all of us being a party to that. That took some time to establish, and then we built the principles based on that principle that this would be collaborative approach. So the principles were with the legal advisors. Now, the legal advisor would never agree to those principles, but their input was very, very valuable, and we did adjust those principles with their feedback. So by the time we got to the October, and by the time we got to at the end of the 2023, we were in a position where we had a bunch of principles which people appeared to be very comfortable with working within, although they weren't signed off, that they had input from a number of third parties, including postmasters and, more importantly, their legal advisors. And that's when we shared all that journey all the way along through governance in Post Office and indeed with government as well, to ensure everybody was comfortable with the approach we were taking of that process. And there were some really good behaviours were seen by everybody in that respect, in getting to an outcome, a remediation outcome that we could take the postmasters through.
And I think you say in your 7th statement that full claims not involving novel heads of loss now take around 40 working days.
Yeah.
Is that right?
So we're absolutely aware that new nuances, new principles, new heads of loss will appear. And we have a process that wraps those in as well, which again have to go through governance. Now, as soon as a new principle or a new heads of loss has to be reviewed, of course, we have to understand the financial impact, and we have a huge modelling exercise that we go through to say, right, if you're going to now embrace that new heads of loss, to your point earlier, what's the impact on anything that you've already done? And what's the impact going forward, and how is that going to affect the financial modelling, indeed the provisioning, etc., etc. So all that exercise has to be done with government approval.
Thank you. Could we bring back up onto screen your 7th witness statement, please? WITN 09890700. It's paragraph 86 on page 30. Paragraph 86. As at the 28th of August 2024, all claimants except 3 have received a payment in some form, whether an interim payment or final settlement payment. These 3 claimants had their convictions overturned between late January and August 2024. All 3 have been sent an interim payment application form, with 1 claimant accepting the interim payment. This interim payment was made on the 2nd of September 2024. Can you assist us with how many pecuniary claims have finally settled and how many are outstanding, or an indication of that?
So what I can is hopefully assist with, I probably have somewhere got the complete breakdown. I'm happy to supply that to you. What I can hopefully help the inquiry with, out of the 111 cases, because that's a fixed population now because of mass exoneration. So that out of the 111 cases, 61 have settled. The vast majority of those are the 600,000. But there are other cases that are above 600,000 that have settled. So 61 settled. There remain 50 cases. Of the remaining 50 cases, every single one to this point in paragraph 86, every single one has had at least a minimum payment of £200,000. Many of them have settled on non-pecuniaries, and some of them have settled on pecuniaries as well. I haven't got that precise breakdown here. I think it is in my statement of as it was at the end of May. I'm happy to provide the inquiry with updated figures on that.
Thank you very much. So we're going to shortly break for the day. Mr. Recaldin is able to come back tomorrow morning, and we are able to accommodate Ms. Mumby to be completed within the day as well.
That's fine. Just 2 rather pedantic points, Mr. Recaldin. When you say that the number 111 is now closed, technically that may not be right.
Ooh, you're absolutely right.
In the sense that there could be non-convicted but prosecuted postmasters who would come forward still, and there could be, if you were right about this, postmasters who had been cautioned who have not yet come forward.
You're absolutely right, of course, Sir Wynne.
Well, he doesn't. No, I could be wrong.
No, you're absolutely right. Look, but in my head is absolutely the funding allows the prosecuted, not convicted population into the OC funding space. But because they're not convicted case, I haven't included. So in terms of overturned convictions, my understanding is a lockdown population. Thank you for the clarity. You're absolutely right.
But the reason I was thinking about that was, and I certainly may be wrong about this, I hadn't appreciated previously that cautioned postmasters were within OC. And when I was reading the section of your witness statement, which deals with prosecuted but non-convicted cohort, paragraph 29 onwards, don't bring it up now, I'll just ask you to look at it overnight. There's no mention of cautioned sub-postmasters, and I'm very happy that you may be right about it, but I would like you to clarify that for me, if you would.
Sir, I would appreciate the opportunity to clarity, and I think Mr. Blake also pointed out in the funding arrangement it didn't refer to the word caution either. And as soon as I've said that, I'm now doubting myself. So I'm pretty sure it does, but I need to thank you for the opportunity for me to go and seek clarity. I will do that overnight.
That's fine. Thank you. Well, thank you very much for giving evidence all day. And I'll see you, I think it's 10 o'clock, Mr. Blake, tomorrow?
Yes, we can accommodate both Mr. Recaldin and Ms. Mumby tomorrow, even with a 10 o'clock start.
Right. Well, that's fine. And so I'll see you at 10 o'clock tomorrow.
So can I just clarify for Mr. Recaldin, obviously he can't speak to anybody about his evidence subject to that one issue relating to the caution.
Yeah, I think that must be right, Mr. Recaldin. You're not supposed to speak about your evidence unless I specifically allow you to do so, and certainly in relation to the clarification which I have provoked, you can speak to whoever you think is appropriate, all right?
Thank you, Swin.
Yeah.
Thank you, sir.